My lord, the first defendant and second defendant are not yet present.
Yes. Have you heard from them this morning, apart from the thing you emailed me about?
No.
No. Well, let's give them a few minutes. I'm going to block my camera and microphone for about, what time is it now?
11:30 Dubai time.
Right, I'll give it 5 and then, but I'll be listening in case you want to call me. Yes, Mr.
I don't know what Mohammed may have given you, but we were served overnight with an application to hold the trial, which is under the inherent powers of the Honourable Court.
That's what I was referring to.
I'm grateful.
Yes, thank you. I'll be within earshot if you want to call me back.
Lord, yes.
Yes, my lord.
Have we heard anything from Mr. Mehta?
No, my lord.
Right. What I think I should do, Mr. Reed, is ask my clerk to take steps to contact Mr. Mehta, see whether he is about to turn up or whether he has other plans, and maybe that I suspect will take at least until another 20 minutes or so. So unless you have any particular alternative proposal, that's what I would propose to do. And shall we resume on the hour at 9 o'clock UK time, 12 o'clock Dubai time, 1:30 India time?
Thank you.
And if anything in the meantime, send me an email, or I may or may not be on this available here on the screen, but send me an email or even phone me. You have my number, I think, Mohammed.
Yes, my lord.
Yeah.
I can
Okay.
get it from Cheryl as well.
Yeah, we'll resume at in 23 minutes. Thank you.
Okay, my lord.
He would have contacted, if he wanted to attend, he would have contacted the court. Would it be just by email?
If he didn't want to attend, it would be by email.
If he did want to attend, it would be by email as well, or would he have a phone number?
Right now on our CMS, I do not have a phone number for him.
No. But could he have tried to call?
Yes, he could have tried to call. Yes. But we haven't received any calls.
You haven't received any calls?
No. I don't have a phone number for Renish Petrochem either, my lord.
No. Very well. I think we should probably proceed on the basis that he may, if Mr. Mehta appears, we can take stock of the position then, and maybe have to redo some of what we have done in the meantime. But we'll proceed for the moment on the basis that, for all we know, he's not proposing to appear. And if you could make a note of that, and we'll take it from here. Mr. Reed, do you want to, what do you suggest we do?
Well, my lord, I think firstly we should deal with the new application. I think the court should dispose of that application. It is, as I understand it, the fourth application now for a deferment of trial. If one considers his application to defer the hearing of the contempt committal application, then this is his fifth deferment application. So in order that it be clear that the first and second defendants are failing to attend the trial, I think we formally have to dispose of the new application, albeit that neither of the first and second defendant are here to prosecute that application.
Yes, Mohammed.
My lord, should I start out by reading the statement?
Yes, I'm sorry. That's right. I think yes.
This hearing is in the matter CFI 054/2018 before Justice Lord Angus Glennie and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Denton & Co. Lead counsel is Rupert Reed QC. The first defendant is not present. The second defendant is not present.
Yes, thank you. Mr. Reed, you were saying that I ought to dispose of the new application for an adjournment. Looking through the grounds of the application, paragraph 3 seems to suggest that I should adjourn pending an appeal against my refusal of an adjournment. Paragraph 4 wants me to adjourn pending the decision of a case raised against Prime in Sharjah. I should have said I don't see any substance in the ground of adjourning pending an appeal. That's both paragraphs 2 and 3. The case in Sharjah, if it's been raised, has only been raised very recently, and I don't see that as a basis for refusing for adjourning this case.
No, and insofar as the first and second defendant would essentially be seeking contribution, that is their entitlement. But the claimant has now had its claim outstanding since 2018. We're now 3 years on, and it would be extremely prejudicial to my client, to the claimant, to be required to wait whilst some proceedings are pursued in Sharjah. We have no idea of the scope of those proceedings, no idea of what is claimed,
Yes.
merely a case number. And as your lordship says, we're informed of that extremely late in the day. So we would resist any application to defer by reference to the Sharjah or the alleged Sharjah proceedings. And similarly, in respect of an appeal, again, it would be highly prejudicial. We're unaware of any appeal actually having been made. The trial date has been listed now for several months. Various deferment applications have already been made and rejected. And in our submission, this would be transparent gaming in order to try to put off the trial date, which would create a real injustice to the claimant in pursuing its claim.
And the paragraph 5 deals with a suggested discussion to settle the case, but that's not anything to do with the court.
It is also explicitly without prejudice, and it is perfectly plain.
To be clear, can I just be clear? I saw it was marked without prejudice, and I haven't read it for that reason.
Great, that indication.
Then the paragraph 6 is the denial of proper legal representation. We've dealt with that in the sense that it is in Mr. Mehta's own hands as to whether he can release funds to instruct lawyers, and we've discussed this on previous occasions, and there's nothing new arising out of that. The only thing that might be a new point is the medical condition referred to in paragraph 7, but for an adjournment to be granted on those grounds, there would need to be proper medical evidence before there could be proper discussion about it. And the proper course will be for Mr. Mehta to submit some medical certificate, and then the discussion could proceed from there as to whether that was sufficient to justify an adjournment.
My lord, yes. And I would add that the shock and trauma claim is one that we've seen before in seeking to justify why it was that Mr. Mehta essentially absconded and buried his head in the sand, declined to deal with SBM. He claimed because it was of the shock and trauma that he suffered as a result of the collapse of his business. So, and again, in those circumstances, no medical evidence was submitted. So there does seem to be a pattern in the conduct of Mr. Mehta of alleging shock and trauma, and that he doesn't need to deal with his creditors and indeed with the victims of his fraud and the judicial processes they have brought by reason of his medical condition, which has never been particularised and never been evidenced.
Yes, I think, Mr. Reid, when you make submissions, you mustn't assume that the fraud is proved until later on in the case, if you do prove it. Your submissions tend to presuppose that there is fraud, whereas that's the whole issue at stake in these proceedings. And then I think that nothing arises out of paragraphs 8, 9, and 10. Therefore, I shall refuse this application. Which does it have a number? Well, Mohammed, you will make the formal order in terms of refusing this application, will you, Mohammed?
Yes, my lord.
Thank you.
You're welcome, my lord.
Right. Of course, I should say this, that if Mr. Mehta puts in an appearance today and wants to revisit some of these points, I'm not going to stop him. But at the moment, that's my decision, and we'll proceed on that basis. Now, where do you want to go from here, Mr. Reid?
My lord, I don't know if your lordship has a copy of the rules of the DIFC court to hand.
Yes, I do. Yeah, in a book form.
Good. Well, we are now at page 475 of the book form.
475. Yeah.
And if I could take your lordship to RDC 35.14.
Yeah.
This is the day one of the adjourned trial, and we're therefore in a situation where a defendant has failed to attend trial. And therefore, reading 35.14, the court may proceed with a trial in the absence of a party, but, and then going to sub-rule 3, if a defendant does not attend, it may strike out his defence or counterclaim, or both. The claimant may prove his claim at trial and obtain judgment on his claim and for costs. Your lordship will see the note 35.14.1, which suggests the court's approach when a party fails to attend trial. And the note reads, RDC 35.14 gives the court a discretion where a party fails to attend trial. It may, but is not obliged to, strike out the absent party's statement of case and proceed accordingly. Nevertheless, the court's practice appears to be to strike out the absent party's statement of case and proceed on the basis of the other party's case alone.
Yeah.
Just to clarify the position of the claimant, we would not seek to strike out the statement of case, and we would not seek, therefore, judgment on the basis of a strikeout. We would seek to prove our claim at trial. And in terms of the evidence that is now before the court, the position is this: the claimant's evidence is unchallenged because the defendant has failed to attend.
Well, there's no evidence yet. And there's potential evidence which has been lodged, it hasn't been adduced yet.
It hasn't been adduced yet. So, but in terms of the claimant's evidence, the claimant is here. The claimant has adduced its evidence. The claimant's witnesses have been tendered. They are ready to give evidence. And that evidence, the formal position is that that evidence is unchallenged.
Yes.
And as for the defendant's evidence, in theory, your lordship is right. That evidence is not before the court because the defendant hasn't attended. If your lordship is minded to consider that evidence, and your lordship will have undoubtedly considered that evidence in preparing for the trial, then in our submission, the weight given to that evidence in circumstances where it is untested and where the first and second defendants have not made their witness, Mr. Mehta, available for cross-examination, the weight attributed to that evidence should be minimal.
Yes.
Now, Your Lordship asked us to burn some midnight oil on Sunday in preparing a new skeleton argument. That work has been done, and I think we all found it very productive in terms of the refocusing of the case.
Yes.
The case against the first and second defendant in deceit is set out in some detail
Yes.
in that document. And indeed, we prepared a list of a selection of the underlying documents which we felt would assist Your Lordship in understanding the claimant's claim. I don't know if Your Lordship has had the opportunity to look through those documents.
I have. I wanted a bit of help on that, and I've looked through those briefly. I was more concerned with making sure I finished all the points in the skeleton before coming on that. But are you going into the merits? Are you going into your case now?
I am, my lord.
Simply out of time to do.
No, I would be very happy to go through our case. As I say, the claimant looks to prove its claim. Clearly, I anticipated that I would be making opening submissions, but in the absence of evidence, I may also be making closing submissions. I may essentially be summing up the claimant's case.
Well, the only problem I can see is this. Mr. Mehta's not here now. There has been a trial timetable which was laid down by the court and agreed by parties, or at least circulated without opposition. I suppose it's possible Mr. Mehta may say, well, no, I didn't turn up on day one, but I want to be there to deal with Mr. Gunness, for example, or to give my own evidence, which is scheduled for day whatever. Is he not entitled to have the timetable kept here?
My lord, no, and for various reasons. You can determine whether a party attends by whether they attend at the beginning of trial. The claimant should not be required to maintain the process of a trial on the basis that at some future point in the timetable, which will invariably have been set before trial, a defendant may wish to engage. It would be extremely unfair in my submission to the claimant in circumstances where these defendants have not paid on the existing contractual claim. They've showed no indication that they have any intention of paying any judgment this court orders. And the claimant would then be in a position to continue going through the motions, if you like, a trial, spending days preparing, for example, for the cross-examination on the basis that Mr. Mehta may turn up on day 5 of the trial and attend for cross-examination. This court has to decide whether RDC 3514 is engaged, and it does so by reference to whether whether the first and second defendants attend the trial. And this date, the adjourned start date, is well known to the first and second defendant. He was well aware of the consequences of not attending trial. The application to adjourn is, in my submission, a bad application and has been rightly denied by the court. I'm perfectly prepared to make the claimant's case on the basis that it may be an opening if Mr. Mehta attends today, but I think at the end of today, this court will need to decide whether what I've done is an opening, and that would be the consequence. For example, if Mr. Mehta were to attend. Mm-hmm. Alternatively, that it be a closing, and that we then close the trial. But I say that, my lord, by way of indulgence. In my submission, Mr. Mehta has not attended. We've given him half an hour to contact the court if there were any issue, and he has not done so. And I would make the further point that, and your lordship may remember from the set-aside application, that if if judgment is made against a party in their absence, and if I could, sorry to take your lordship back to the blue book, which I think your lordship may just have put away.
Yeah.
If I could take your lordship to page 476.
Yeah.
At RDC 3516,
Mm-hmm.
reading from that, where a party does not attend and the court gives judgment or makes an order against him, the party who failed to attend may apply in accordance with Part 23 for the judgment or order to be set aside. And 3517 makes
that might apply even to at this stage of the proceedings.
Even at this stage.
If
Your Lordship
made an order, yeah. Okay.
And your Lordship, remember, your Lordship made a distinction between setting aside an immediate judgment and setting aside a trial judgment on the basis that the onus in setting aside a trial judgment was significantly higher. So we see from 3518, it would be necessary for the first and second defendants as applicants to show that they had acted promptly when they found out the court had exercised its power to strike out or enter judgment or make an order against them, had a good reason for not attending the trial, and has a reasonable prospect of success at the trial. So if there has been some traffic accident that explains, then clearly the first and second defendants would have a remedy under RDC 3516, but they would need to show that they had acted promptly and that there was a good reason for their not attending trial.
Yeah, that's helpful. Thank you very much. I'd forgotten about that. Can I put this away again? Right.
So, my Lord, this is a claim in deceit against Renish and Mr. Mehta based on twin representations. Firstly, those in negotiating the facility agreement 2017, and secondly, those in requesting payments under that agreement in the course of 2018. The representations on which the claimant relies are implied representations, and they are primarily, one, an intention to repay all of the finances. And it is, of course, accepted, my Lord, that payments 1 to 3 under the facility were, in fact, repaid. But in our submission, that is nothing to the point, because that is a very common feature of many forms of finance fraud, where the fraudster, and I will say the fraudster rather than the purported or the alleged fraudster, and I hope your Lordship will indulge me in this, but where the fraudster pursues a number of transactions with a view to building confidence on the part of the financier and with a view to building up the extent of the indebtedness under the relevant facility. It's rare that a financier allows a borrower to use the full extent of the full limit of the facility at the opening of the borrowing the finance relationship. The second implied representation is that there was a bonus.
Sorry, you'll have to forgive me if I keep interrupting. You say you accept, of course, that the first 3 payments were, first 3 loans were repaid. You treat in the same way, do you, the advances for other non-prime contracts, which are listed in your document at page 5485?
My document.
Well, sorry, E5485.
There were other transactions that were financed, and we accept that those were repaid.
And that is, just so I have your position clearly, that is also part of the fraud, lulling the bank into confidence by putting through some genuine transactions.
Yes.
Yeah. And do you have any? You obviously don't have direct evidence on this, but any evidence from which you can infer that that was the purpose of putting through the genuine transactions?
Well, my Lord, in terms of inference, one has to look at the case in the round, and there is a problem with fraud cases if one attempts to salami slice particular elements and look for direct evidence of the relevant elements, so an intention, reliance, intended reliance, loss, in respect of each element. One has to look at all of the activity in the round in assessing the relevant knowledge and intention.
But it doesn't obviate the need for some sort of forensic analysis, rather than just relying on the fact, well, he didn't pay, he ran away, etc. Therefore, it must be fraudulent at the beginning. You can't.
I don't think we place a lot of reliance on the previous transactions. I don't think we have to place very much weight on those. I think there is sufficient evidence in respect of other elements of the fraud. But what we do say, and we say it strongly, is that the mere fact that the defendant has made certain repayments in the early stages of a finance relationship does not show innocence, does not show that they had no fraudulent knowledge or intention. It's entirely consistent with the relevant intention.
But do you accept that it could be used to counter that argument, to say, look, this is perfectly genuine, facility agreement. We used it for all sorts of business, including non-prime stuff, and have a record of repaying similar amounts from November 2017 right through to March, April 2018.
Yeah, I mean, those were letters. That was a letter of credit. Those were letters of credit. So it was a different facility. To be, I would accept that it cuts both ways. I think I can say.
If you're going to draw a distinction about the letter of credit, can you just help me on that then? I mean, they're not all letters of credit. I'm looking at
looks at the table on E5485. You're right. There are various of them are import loans to other suppliers, and I think 3 or 2 are letters of credit.
Yeah. So right from November, you say there was this intention to defraud, intention to end up with borrowing 30 million and not repaying it.
My lord, yes. And if one looks at the prior trading, there will obviously be some small measure of profit. Sorry, yes. There will always be some element of profit, but the profit element on a relatively small number of other transactions is minimal compared to the proceeds of what we allege to be the fraud. So if one looks at it in that context, the real, the substantial profit from the perspective of the first and second defendant is in the trade finance, which was essentially taken.
Okay.
The second implied representation, so we've dealt with the intention to repay all of the finance, and obviously all is important in that context of there being an intention to build the amount of the indebtedness and then at a point when the limit had been reached to abscond. The second implied representation is one that there was a bona fide transaction that required payment in advance, and that we say is in the nature of trade finance. The finance is needed to bridge a gap between when the supplier will require payment in advance and when the purchaser is willing to pay. And the documents that are presented to SBM included representations as to Prime's requirement for payment in advance. Those documents, we say, are shams, because these businesses are essentially working together as one business. And it is absolutely clear, both on the evidence and on the opinions of both of the expert accountants, that in fact Prime did not require payment in advance, consistently with what is in the both the invoice and the Prime contract.
Can we just be clear as to this? You refer in your skeleton argument on a number of occasions to the evidence of the third defendant's witnesses, both their expert evidence and Mr. Sada's evidence. That is not being adduced. What is your position about the formal status of that evidence?
Well, we say it's on the trial bundle. It has not formally been adduced. It has minimal weight because it cannot be cross-examined. But to the extent that it corroborates what we say, we have relied on it. We've made that clear in our skeleton. the extent to which we do rely on it. We make very limited reference to it, particularly the evidence of Mr. Drew, the expert accountant, because we say fundamentally he carried out the wrong exercise. But the most useful document actually from Mr. Drew is actually the joint experts report, where he confirms that you cannot essentially trace through the exchanges to NEOC that the attempts to correspond transactions is problematic, and also that it is quite clear that Prime was not, in fact, requiring payment in advance.
Sorry, I'm asking though about the status at the moment of the third defendant's evidence. Mr. Sada, Mr. Drew, and the other gentleman. Are you saying I can take it into account for and against you?
My lord, yes. But we do say that it should be accorded little weight. We do not place any significant weight on that evidence. Where, however, it's consistent with our case, we will bring that to the court's attention and have done so in the skeleton argument.
Yeah. Okay, that's helpful. Thank you. Right, so your second point, though, is the representation was that the bona fide purchasers required payment in advance.
Yes, yeah. The representation that there was a bona fide transaction that required payment in advance, when there wasn't a bona fide transaction, there was a sham contract, and the reality was that no payment was required in advance. And the third implied representation is an intention to use the payments to purchase consignments of oil to be shipped to Lanka. And in fact, there is no documentary evidence.
Sorry, I'm just trying to take notes in an old-fashioned way, so if you can bear with me. Sorry, the third representation.
That there was an intention to use the payments, to purchase consignments of oil that were to be shipped to Lanka. And your lordship will have seen that generally, in respect of all of the 6 deals, cargoes, the payments were not, in fact, used to purchase consignments of oil. There is no documentary evidence in respect of any of the 6 cargoes that specific consignments were purchased and delivered to Renish in the UAE. And in respect of cargoes 4 to 6, 4, 5, and 6, no cargoes.
Sorry, in respect of which cargoes?
4, 5, and 6, my lord.
Yeah.
The last 3 under the second tender award.
Yeah.
No cargoes, no oil was ever delivered to Lanka.
Yeah.
Now, it's obviously fundamental to trade finance that if you request finance in order to purchase specific goods, you cannot then use the finance for other purposes. There are essentially 2 species of trade finance. There's less serious trade finance fraud, if I can possibly call it that, whereby you represent that finance is going to be used for purpose A, but then use it for purpose B. That is a species of trade finance fraud, arguably less malign than the second species. The second species is where the trader seeks the finance for a specific purpose and then takes the money and absconds. And we, in our submission, are dealing with the second case. But even on the second case, it is quite clear that the finance is not being used for the stated purpose. The stated purpose being to purchase consignments of oil to be supplied to Lanka. And in our submission, there was no such intention, specifically in respect of the 4th, 5th, and 6th cargoes. But the same point can be made more generally in respect of all of the SBM payments.
All the SBM payments involving Prime, or all of them?
The ones involving Prime, sorry, I'm dealing with 1 to 6.
So even where the oil was bought for Lanka, it wasn't bought using the loan for the purpose which it was represented it was to be used. That's your point, isn't it?
That's the point.
Yeah.
And when one looks at the use of the funds, even in respect of cargoes 1, 2, 3, it isn't a case of the funds being provided to Prime in order that Prime can purchase the oil and Prime then delivering it. As we will see, the monies are used for other purposes. So we see payments, for example, to other entities, payments to other individuals, payments back to Renish, none of which make any sense as a matter of trade finance.
Yeah. Mm-hmm.
Your Lordship will have seen from our skeleton that the question is now limited to Article 31 of the Law of Obligations. So all of the issues of conspiracy, all of the issues of unjust enrichment are now gone. And
Yeah.
in terms of the framework of the analysis under Article 31, the relevant elements that we need to show are a fraudulent statement.
If you just give me a second, I'll just get it out. Page.
That's out in our supplemental skeleton.
Yeah, page.
A147, Lord.
Yeah. Mm-hmm.
So, defendant is liable indeed if he makes a statement that is fraudulent. So, we'll be looking at that. The second element, B, he intends that the claimant should rely. Pausing there, we say the representations were made in order to induce SBM to enter the facility agreement and to make the payments. So we say clear intention of the claimant's reliance. Little c, the claimant relies on the statement, and we say that the SBM in entering the facility agreement and advancing each of the payments clearly relies. And then little d, the claimant suffers loss as a result. Well, the claimant has been left $30 million out of pocket. And in our submission, that is clear as an element of loss. The issue, therefore, is whether the representations were fraudulent. So the issue is under little a, and we see in sub-article 2 that a statement is fraudulent if its maker knows it is false, or b, has no belief in its truth, or c, is reckless as to whether it's true or false.
Yeah.
So the question is not dishonesty in the classic sense of looking at the standards of reasonable and honest people, whether objectively or subjectively. The question is whether the maker of the implied representations, that's Renish and Mr. Mehta, knew that they were false, knew that they had no intention to repay in full, knew that the relevant contracts were not bona fide arm's length commercial arrangements, but were sham agreements, and had that relevant knowledge and relevant intention. In terms of pleading, one is entitled to plead knowledge and intention without a significant infrastructure in terms of primary facts on which the inference of knowledge or intention is drawn.
Where did you get that from?
Well, I'll come to that when we deal with law. at the end. But certainly what I can say is that all of the law in respect of the need to plead primary facts it specifically relates to the issue of dishonesty. And dishonesty, we say, is more complex in terms of being of showing the inconsistency with the standards of reasonable and honest people.
Yeah, but in any case, if you're saying someone has made a false statement, you need to set out the facts you rely upon that you intend to prove if they're disputed to justify that inference. If it is an inference. And what worried me when I was reading your skeleton argument was there's quite a lot of detail given, which I'd have thought ought to have found its way into the pleadings to give fair notice of the case you're making.
Well, I will come on to that, my lord, in terms of what our primary facts were.
Yeah.
So in terms of the representations, we say all of the relevant dealings with SPM were by Renish and its employees. So there is no issue as to who made the relevant representations. Renish was the borrower, and Prime was ostensibly.
You needn't spend long on this aspect.
As I've said, the reality was that the commercial arrangements were sham. They were never at arm's length, and we will see how Prime and Renish were in effect functioning as a single enterprise. And Prime never, in fact, required payment in advance. And what in fact occurred is that the Renish continued making repayments until precisely the moment when it reached the maximum level of the facility. So on the 6th of June, the 6th payment was made. That took the indebtedness up to 30 million, which was the limit. And thereafter, no repayment was made by Renish. And on the 22nd of June, Renish fell into default.
Now,
that was the.
Sorry, can you help me on that? Are you saying that's the first time the indebtedness reached 30 million?
Yes, my lord, yes.
And that includes all the transactions that we've just referred to at 5485. There was never a point there when the indebtedness reached.
I will seek instructions on that point over the lunch hour, but my understanding is that is the case.
Right.
We have advanced that case in our skeleton, and we will seek to confirm that. Yes, my Mr. Wheel thinks that at one point it may have hit 28 million, but it didn't hit 30 million.
Right. If you're able to identify that for me at some stage.
We will
at least 28 million.
Do that over the lunch adjournment, my lord.
Thank you.
And we say it's a reasonable inference that what occurred was what was in fact intended. And there was no intention to make a full repayment under the facility. And we say, in terms of the compelling case of fraud, it's clear on the evidence and indeed on the expert assessment that Prime didn't require payment in advance. We say that the monies were almost immediately paid on, and your lordship was in reference to the onward payments, paid on to various third parties and indeed back to Renish. And your lordship will have seen the table at paragraph 58 of the particulars of claim. I'll refer to as table 58. That's at page B24 for your lordship's note.
I just got it here, so give me a second.
I should say that both of the experts accepted Table 58, and indeed Ms. Levin incorporated it within her.
Yeah.
I should also add, by way of caveat, this only shows the direct beneficiaries. So, for example, it is suggested, if you look at this table, it's suggested that PetroMaster, or Petro Hub, received only 3.4 million. But your lordship will be aware there are primary beneficiaries, secondary beneficiaries, and tertiary beneficiaries. So although monies may not have been directly paid out to these recipients, they may in fact have received them as secondary or tertiary recipients. And I don't know if your lordship, the very helpful tables in Ms. Levin's report.
I haven't looked at those. So if you want me to look at them, where are they?
They are page G55 and following, Lord.
Actually, I'm sorry. You'll have to bear with it. It's in another room.
Don't worry.
Give me a sec.
Of course, my lord.
Yeah. Page what?
Yeah, my lord, looking at page G55, for example.
Hang on.
It's actually quite, because it's landscape and tiny.
Yeah.
So this is SBM payment 1, and you'll see a graphic at the top showing SBM and then a 1, and then a payment made to Prime Energy, and then a secondary payment to Prime Energy, an internal transfer to the AED account, the dirham account rather than the dollar account.
Yeah.
And then third, an onward payment to entities Neon and Helios.
Yeah.
So table 58 shows where the monies were transferred in terms of the direct payment out of the Prime US dollar account, but doesn't reflect the payments from that account. So if I could just take another example.
Hold on 1 second. Sorry, I'm just turning up table 58 again. Yeah. So, sorry, just 1 sec. Table 58 shows, for example, that first one.
These are totals, my lord. So Prime Energy will have received, by way of transfers out of the Prime dollar account, so internal transfers to another Prime account is $11.6 million.
And that presumably is explained by converting from dollars for a dollar account to a dirham account, maybe.
Yes, it is. That's the internal transfer that I think is had in mind.
Yeah.
And the
actually, then we see that although went to Prime Energy dirham account and then was distributed to Neon and Helios. Yeah.
My lord, yes.
Yeah, and you want to show me another one?
Well, I was just going to show you another one. So if one looks at page G64.
Yeah. Mm-hmm.
One see, so looking again at the graphic, SBM transfers to Prime Energy, and then there are various secondary recipients: Petro Hub, Renish, Prime Energy, Dirham account, Petro Master, Mr. Abdul Farhang, and Mr. Ali Didvar Sado. Sorry, that's Ali Sado.
Yeah.
So you'll see there that there are certain payments made to Mr. Farhang and to Mr. Sado.
Yeah.
And those you can see on page G65.
Mm-hmm.
In the landscape format. At the bottom of that page, you'll see Mr. Farhang as a recipient receiving $304,000 US.
Sorry, where do I see it? Oh, I see.
So and looking at it in landscape, as I say, the last row.
Yeah, okay. Yeah, I follow it. Yeah.
And over page 6, G66.
Yeah.
See the second row down, again, recipient information, Mr. Ali Sada.
Yeah.
So table 58 is a helpful summary, but hides a lot of the complexity that one sees in these very helpful appendices that Ms. Lavin has prepared, showing the onward payments and the primary onward payments and then the secondary onward payments.
Yeah. That's helpful. Thank you. Are we to keep this bundle out?
Yes, we don't. I don't need G for a while. As for the third parties, the pleaded case of Renish and Mehta, the first two defendants, is that they have any direct or indirect with those parties. And I think we need to look very briefly at page B198, my lord, which is a critical paragraph of the defendant's pleading.
Yeah. So this is in the context of them saying that they have no connection at all with Prime.
Yes. As your lordship will see, this is in direct response in dealing with I'm going to call it table 58.
Yeah.
So importantly, at subparagraph 2, none of the other companies named is or was part of the Renish group. So a denial of any subsidiary relationship, assuming that it's taking a formal definition of group. And then subparagraph 3, nor was there any connection, direct or indirect, between these companies and Renish, save only that, as it happens, Petro Hub was personally owned by Mr. Ahmed Ayaz, the CEO's, it's Renish's erstwhile CEO, a factor which is of no relevance to the case. That's a very curious pleading. That's a suggestion that the fact that large sums were passed out to Petro Hub, which is the 100% owned by the CEO of Renish, the very man who had negotiated the facility agreement, is of no relevance to the case. That, in our submission, is an extraordinary submission.
Yeah.
But in any event, that makes it all the more strange if there is no connection, direct or indirect, as those monies should have been paid to those recipients. Renish has borrowed this money for a specific purpose, to pay for specific consignments of ore. And yet what we find is the
Yeah. So you've got
Mohammed, we appear to have some interference.
Yes, but everybody's microphone is muted, so I don't know where it's coming from.
Well, it seems to have abated.
It's not here. It could be in your, near your window. Yeah. Anyway,
My lord, if I can just do a quick test of something, if that's all right.
of course, if it's relevant to proceedings, yeah.
Uh-huh.
That seems much better, Mohammed.
Yes, but my lord, I've muted you, so you will have to unmute. It seems that there's a problem on with your microphone. My apologies. My lord, you're still muted. There we go.
Could it be because I got a phone on nearby, or is that nothing to do with it?
I don't know, my lord. If you'd like, I can ask Ajaz to come in and see what he can
Well,
maybe do a troubleshoot.
I can hear fine. So unless Mr. Reed, you want to?
No, my lord, it is reduced.
Right. Okay, we'll carry on then. Thank you.
So as we've looked at the transfers to third parties and the pleading by the first and second defendants in respect of those, in respect of the payments back to Renish, we see at subparagraph 4 that none of the disbursements, save only the three mentioned in paragraphs 55 to 56, sorry, 56 to 57, totaling $7,886,000, was to or for the benefit of Renish. So an implicit admission of those transfers to Renish. And it's further said that these were strictly transfers in the ordinary course of business. So, and it should be said that the transfers of the fifth and sixth payments were almost immediately transferred to Renish. And we cannot understand how it can possibly be said to be in the ordinary course of business for a buyer to be seeking trade finance, which is paid in the ordinary course to the seller of the relevant oil, but the seller immediately transfers that finance back to the buyer or back to the buyer. That is entirely inconsistent with the ordinary course of trade finance.
Can I just ask you, the 7,886,000 figure, is that a figure which you say more than that was paid to Renish, or is that the correct figure?
That is the correct figure.
Yeah, thank you.
And it's picking up the references to those payments in paragraphs 56 and 57 in the particulars of claim that immediately precede table 58.
Yeah, thank you. Okay.
And indeed, I should add that there was a further, our understanding is there a further 3 million that was advanced to Renish under payment 4. And the reference for that is G61, Lord.
Yeah.
And we further, quite apart from the logic or the normal structuring of trade finance, when one looks at the sixth payment, as we will, and one sees that 1.7 million is paid to Noven and 5 million is paid on to Astron, neither of which in any way participates in oil trading.
Give me those figures again.
1.7 million is paid to Noven.
Yeah.
And 5 million paid to Astron. I'm very happy to take a lordship to Miss Labin's appendix on that, if you would.
No, don't worry, you've mentioned these in your skeleton.
We see it is completely incomprehensible that the defendant should assert that those transactions and payments are strictly in the ordinary course of business, given that neither of those entities has any involvement in the relevant business. But it's even more incomprehensible that they plead that case in circumstances where they offer no explanation as to why the money should be paid to those entities, which, as I say, have nothing to do with the oil business.
The payments you're talking about are by Prime, is that right?
And these... I just need to remind myself, but the payments would have been initiated, the monies would have come out of the Prime NBK dollar account because SBM pays into that NBK account. They came directly to Novin and Astra, and I will just remind myself now in G. I don't want to make a... So payments is 6 is at G68 in Miss Laban's appendices.
Yeah.
Your Lordship is right, looking at the first row, looking at the graphic. So SBM pays to Prime's US dollar account, that's the MBK account, and the monies come out of that and are paid to Novin and Astron. So the bottom of page G68, the bottom row, we have the payments to Novin of 1.7 million, and then over page G69, the bottom row, again the 10th of June, we have the payment to Astron of the 5 payments to Astron totaling $5 million.
Yeah.
And I should say that the general impression one has is that by the end, when you're looking at the 5th and 6th payments, there's a little less concern about who the monies are paid out to, about trying to maintain some sort of pretense of trade finance. Some of the subtlety, we say, of the fraud has been lost by that later stage.
Yeah.
And there is no evidence that any part of payments 4, 5, or 6 was applied towards the purchase of any consignment of oil for Lanka. And we say there can have been no genuine belief on the part of Mr. Mehta or any of the relevant officers of Renish that the payments were being applied for that purpose.
And this is not just a question of sequencing. So one of your points is that the representation was that money was required for payment in advance. But I think this point is a slightly wider one, namely that it wasn't used either for payment in advance or after or subsequent to the purchase. Is that right?
Lord, yes.
Yeah.
Exactly right. And there's no evidence of any cargoes of oil being shipped to Renish pursuant to the 4th, 5th, or 6th payments. And of course, we say that Renish would have known that cargoes 4, 5, and 6 would not be delivered. And that is precisely why in mid-June 2018, we see a stalling exercise where Renish is seeking to produce excuses for a delay, an alleged delay in shipping cargo 4. Renish knew full well that the cargo would not be delivered. It knew that Lanka would make no payment. And if Lanka made no payment, there would be a default in the repayment of the 4th payment. And that would happen on the 22nd of June. And the logic of this sort of trade finance fraud is that the fraudster needs to abscond, because otherwise, as soon as they've fallen into default, they will be subject to contractual claims. They and their assets need to disappear from the jurisdiction.
Mm-hmm.
Now, one thing that Renish and Mr. Mehta could have done, but have not, is to seek to distance themselves from Prime. So the argument might have been open to them to say, well, as far as we knew, SBM paid monies to Prime. We didn't know that Prime had misapplied those monies. Well, that argument simply isn't available for a number of reasons.
Mm-hmm.
Firstly, that a large part of the monies were paid back to Renish. But more fundamentally, the reality was that Renish and Prime were hand in glove.
Mm-hmm.
Prime had almost no independent existence. He had no office. It had no employees. It had Mr. Sadder as a consultant with his laptop and mobile phone. Prime was using Renish's staff for all of its UAE dealings. And specifically, setting up and operating the NBK bank accounts, I should say. Those bank accounts had been opened in early 2017, indeed in February 2017, at the very time that the SBM facility was being negotiated. And it is the claimant's case that they were opened as a receptacle for SBM's funds and indeed to facilitate the speedy transfer of round sum numbers, with minimal bank scrutiny. And as we'll see, Mr. Sadder is very candid about the fact that the reason that Prime opened the NBK accounts was that those transactions, those transfers would be facilitated, including transfers of round figure sums between the two, between Prime's accounts and Renish's accounts. And indeed, we'll see too the indications of the sort of transactions that were expected. And it was precisely that information. It was round figure transactions in large sums in both directions. And it was that anticipation was communicated to the bank in order that the bank would not question or scrutinize those transactions as and when they occurred. And it is Renish staff who not only set up the bank accounts, not only operated those bank accounts, made the payments out of those bank accounts, but repeatedly present sham Prime documents. Now, the core documents for our purposes are, of course, the Prime contracts, so-called, and the pro forma invoices. They were the key documents in the package of documents that Renish submitted to the bank in seeking each of the relevant payments.
The contracts plus what?
The pro forma invoice, or the PI, if you want to.
Pro forma invoice as well. Yeah.
But there were a number of other sham documents that we will look at. There was, for example, as part of the stalling exercise in June 2018, there was a sham exchange apparently between Prime and Renish in respect of a delay. So Prime, as the supplier, saying, well, we have a problem, there will be a delay. Renish, as the purchaser, pushing back on that and explaining that their customer was insistent on prompt supply provision. And that exchange was in fact a sham exchange between Renish employees, one of whom was using a Prime footer and sending his email from a Prime email account.
Mm-hmm.
There is also a certificate of origin that is produced, again, on Prime-headed paper. And we see the correspondence within Renish, where there's a reference to the fact that we'll essentially knock up this document on Prime's letterhead, the very same letterhead that is used for the Prime contracts. And so
you say there's
a pattern of conduct whereby Renish employees. Sorry, my lord.
Did you say there was a particular document you were referring to about the certificate of origin?
Yes, well, I'll take you in due course to the certificate of origin, and we'll see it's exactly the same format as the Prime contract, the same letterhead, and it is a document that has clearly been produced by Renish employees as a sham document. It's not only as a sham document, it's also a blatantly fraudulent document because it's an assertion that the oil being supplied under the fifth cargo is of UAE origin when it blatantly was not of UAE origin.
Mr. Reed, just interrupting you for a moment. I quite understand your case that these are false documents. But in principle, there's nothing inherently fraudulent about if this had been even an arm's length relationship between Prime depending upon Renish employees to do the paperwork and all the stuff. In other words, Prime existing simply through a man and a laptop and asking the opposite party to the contracts to do the paperwork. Is that?
Yes, they're shams because there is these are not entities.
Just answer my question first. In principle, it is not necessarily fraudulent or a sham to use the employees of one company to do the paperwork for the opposite party to the deal.
But by itself, I would accept that, my lord.
Okay, that's fine. That's what I wanted to know. Yeah. Okay.
But in circumstances where where the use of those Renish employees indicates that there is, as I say, they are the two alleged counterparties are acting as a single enterprise. There is no genuine arm's length bona fide trading relationship between the two, where the alleged buyer is simply producing contractual documentation which does not reflect a real contract, a binding contract. And we know that because none of the conduct is completely inconsistent with the alleged contract. In those circumstances, we say that is a sham and it is a fraudulent implied misrepresentation to rely on that sham.
Okay.
But I take your lordship's limited point that the mere fact that another company prepares documentation is not of itself a fraudulent representation.
Okay.
We will need to look at those documents, Lord, and particularly in my submission, the bogus exchange between Prime and Renish illustrates perfectly the sense to which Renish employees are trying to create an impression or a facade of a commercial relationship between buyer and seller, between Prime and Renish, so Renish and Prime, which is entirely bogus, and the documents produced for that purpose are sham, clearly in our submission, sham documents.
Can I just ask you this? I'm sorry to keep interrupting. I understand your point about these being sham documents, the sham contracts and so on, because you say the transactions that actually happened bore no relation to the content of the documents. But in terms of the first three payments, which involved shipments to Lanka, which Lanka received, there was underlying whatever the documentation may have said, you accept that there clearly was some, contract agreement of some sort, which procured the shipment of the oil, the sale to Renish, and the sale to Lanka.
We would say that Renish and Prime, essentially as a single enterprise, were providing oil to Lanka. We accept that. But whether there was a bona fide legal binding agreement, arm's length agreement, as between Renish and Prime, as between those parties, for the supply from Prime to Renish, in our submission, that was a sham agreement. They were working closely together to present a sham agreement in order to obtain finance. We don't know whether that finance was misapplied in terms of the purposes of the finance, but we accept that Renish did supply oil to Lanka in respect to those first three. But in our submission, that was very much a part of the plan, of the fraudulent plan, because it's by that means and by paying assiduously on time, subject to a minor delay in case of the third payment. It was by that.
Yeah. But your technical point, technical not disparagingly, but your technical point about the documentation being sham applies across the board to all six of the payments and all six of the cargoes that were meant to go to Lanka, including those.
These were not bona fide arm's length commercial arrangements.
Yeah. Yeah. All right.
Now, my lord, there were, and your lordship will have seen various attempts when Prime was acting to explain what happened to the monies. There was an attempt by Prime to identify corresponding contracts. And this was relevant to their case on unjust enrichment, that they had given valid consideration. And it was relevant to Prime's case that it had reason not to appreciate that SBM was providing trade finance. Obviously, that part of the case has fallen away once Prime is no longer party. We cannot link the SBM payments to other corresponding transactions, and we will look at the documentation in respect of the corresponding transactions. But it is clear that you cannot trace through the exchanges. And indeed, both of the experts essentially reached that conclusion. In the case of Miss Lavin, just for your lordship's note, that's at G38, para 546. And then pages G346 to 347.
Mm-hmm.
And the other attempt by Prime was the suggestion of an open ledger. That's to say that the trading between these two entities was almost like a bank account, in there being a bulk set-off, producing a balance at any given moment.
Yep.
Which would in effect produce a credit facility. So whichever party was owed money would therefore be the creditor under that arrangement, as indeed a bank is if you have a credit in a bank account. That case theory was pursued in particular by Mr. Drew in assessing the broad equivalence, as he saw it, of various cash inflows and outflows to the prime accounts.
Mm-hmm.
And he made no attempt to verify particular or specific cash flows through, for example, the exchanges. And he simply looked at the prime accounts and the inflows and outflows from those accounts. And in our submission, that is essentially a meaningless exercise. And even Mr. Drew had to accept that there were $103 million of outflows to unknown parties. And for your lordship's note, that's G225, paragraph 3.3.31. And he accepts too that there was no opening balance. So this whole balancing the ledger exercise in circumstances where one doesn't know what the position is at the beginning means that if money is paid, for example, to NEOC, one has no idea whether it's money that is an inflow from SBN or whether it could have been money that was already in such a ledger. And indeed, the ledger only deals with trading between Renish and Prime. So to the extent that Prime may have had other monies that came from other trading and could have used those monies to pay producers in Iran or other countries, one has no idea whether it's those monies that were then used to pay the producers, specifically NEOC in Iran.
Mm-hmm.
So the exercise, we say the exercise of Mr. Drew is meaningless and is of no assistance. And we say too that the attempt by Mr. Sadr to attribute certain SBM payments to other oil cargoes asserted by Mr. Sadr to seek to explain why he thought these funds were pouring into the Prime account of the NBK account of Prime. It simply doesn't work, and neither of the experts could make it work.
Can you tell me this? If there had been an open ledger account, whatever that strictly means, between Prime and Renish, in terms of which Prime was purchasing oil, Renish was paying for it, you say that still wouldn't have satisfied the terms of the facility agreement because of the requirement under the facility agreement or the representation of the facility agreement that the money was required as to be paid in advance of purchase.
My lord, yes. And it's precisely when one looks at those, both Mr. Drew and Miss Lavin, on their entirely different approaches, are completely in accord that that Prime was not requiring payment in advance. Yeah. And indeed, Mr. Drew does that by reference to the entire trading, to the inflows from the Prime accounts. So yes, that's exactly what we say. In terms of the, if it is asserted, I mean, I should say that, make clear that Mr. Mehta's case is emphatically that there was no such ledger.
I've seen that, yeah. But, I mean...
So I would hesitate to exculpate him by reference to a factual case which he disavows in the strongest possible terms.
Yes, but so I'm just trying to think in the broader picture. I take your point, or I understand your point about the representation that the money was needed for payment in advance. But the bank, I don't suppose, would have complained had it advanced the money, and Prime had produced the cargoes, and Lanka had then paid, and the bank had been repaid that way. Probably the bank wouldn't care less whether it was in payment in advance or payment subsequently or on a ledger account.
Well, in those circumstances, the bank wouldn't have suffered loss. So,
No. Wouldn't have suffered loss.
But the real world, in the real world, my lord, the bank suffered $30 million of loss because the monies were, we say, misapplied.
Stop at the end of payment 3, just for the moment, or payment 2, if you like. The same sham arrangements were being put before the bank on your case, and yet the bank was being paid. Did it really care?
Well, at that stage, if you go to Article 31, you say, well, we have all of the elements of deceit, but we don't have loss. Therefore, there is no deceit.
Well, have you got reliance? I'm wondering more at the early stage of reliance whether the bank really were fussed about whether the payments were for payments in advance or payment for the oil one way or the other.
Well, they certainly, it was important to them that they were providing trade finance that was necessary in order to pay a supplier. If the bank had appreciated that Renish and Prime were two close companies, essentially trading as a single enterprise, and that Prime was not going to require payment in advance, and that the trade finance was not therefore required in the sense stated, then that would have been a concern. If one looks at the care with which this facility is negotiated over the course of 2017, the care over who the buyer is going to be, that it has to be a major, that it has to be a national producer, the care with which the specific purposes were defined, the care with which every aspect of this trading is defined contractually in a sales note, which then goes before a board committee, which is then very carefully drafted into the facility agreement with all of this relevant, all of those controls put into Schedule 4, the facility limit, the purpose limit. It is, in our submission, entirely evident in the contractual negotiation and in the contractual framework that, yes, it did matter to the bank. Yeah. The bank wasn't, I know a case is made in contributory negligence, bizarrely, against the claimant, but the claimant, as with any provider of trade finance, was very careful in terms of making clear what was important, what was material to the bank in terms of its lending decisions. And indeed, the interest rates, I should say, differ according to who the relevant purchaser is. So if the purchaser is Lanka or a national oil company, that actually results in a discounted interest rate under the facility agreement. So there was close control to precisely that sort of detail. This wasn't a case of a bank riding roughshod and simply providing a load of money and just, as long as we get it back, we don't really mind. And again, another issue for the bank was the whole sanctions issue. And you'll have seen reference in our skeleton to the undertakings, to the representations, to the warranty, that none of this finance was going to be used for business that involved breaches of US sanctions.
Yeah.
And I mean, clearly that is not the representation. Those are not the representations on which we rely. But it is, again, a sense of the care and the attention to detail that was in fact exercised by the bank in negotiating this finance over a relatively long period.
Yeah, no, I take the point.
My Lord, I want at this stage to look at the pleadings. I hear your Lordship's concern, and obviously we're aware that your Lordship had views on the pleadings at the time of the set-aside application. I would like to say that the position has, in our view, moved on substantially because of Denton's letter of the 15th of September this year. Your Lordship should have that.
I find that letter more confusing than the pleadings. But there we are. I've got it. Yeah.
The letter is at I-758.
I have it. Yeah.
So the important points, firstly, is the clarification. And paragraph 2, that the representation was that a facility agreement and the payments were required for the purpose of genuine bona fide purchase. So we say the focus is clearly on the relevant payments. It is not on the wider transactional or trading history. We accept that Mr. Duckworth, in his Skelton argument, sought to make great play of the references to purported transactions, but it was very clear that the representations were that the payments were required for the purpose of genuine bona fide purchases. We were focusing on the specific alleged bona fide purchases. We never sought to impugn the entire trading relationship, and we had no interest in launching a wider judicial investigation. Now, I can see where that impression came from, both in terms of the advocacy of Mr. Duckworth, but also in terms of the evidence of Mr. Sadder, who was, of course, seeking to open the entire trading relationship in order to suggest that the SPM monies seemed to him to be just payments within that wider trading context. But that was not part of our case. And we make a similar point. Sorry, my lord.
I'm mystified by what you, sorry. I'm perhaps failing to pick up the point you're trying to make. Can you just explain again what it is that paragraph 2 of the letter does, which isn't already in paragraph 9 of the pleading?
Well, my lord, yes. We say it is clarification. We say that because the representation was that the facility agreement payments were required for the purpose of genuine bona fide purchases, that the focus was on the relevant payments and the alleged bona fide purchases, i.e. on the specific transactions, not an attempt to impugn the genuine nature of the entire wider trading relationship.
I see. Okay.
And I agree with your lordship that that is clarification, and that in my submission that is implicit in paragraph 9 of the pleading. And my recollection is that there was a certain amount of dust being kicked up at the hearing in terms of the confected outrage that we were seeking to draw into issue every aspect of the purported trading relationship. We make the point in paragraph 3 of this letter.
Yeah.
Yeah, sorry, paragraph 4, I'm grateful. That purported is essentially by way of a non-admission. We had no... I'm a colleague who has a purported expertise in tax law. I'm not saying that he is an expert in tax. I'm not saying that he's not an expert. I'm just saying he purports to have that expertise.
It depends how it's used. And I suspect you and I can argue until the cows come home about this. But you know my view of the use of the word purported in this context. And there's no particular point in dwelling on it or anything.
Well, I do just want to draw to your attention paragraph 5.3 of the reply.
Of the reply, where's that?
Sorry, that's page B106.
Yeah. Yeah.
So as to paragraph 5.3, no admissions are made as to the nature or extent of the alleged or any trading relationship. So no case was being made one way or t'other as to whether the wider transactions were genuine or not.
Mm-hmm. Yeah.
We entirely accept that Prime had its own reasons for putting in issue the entire trading relationship.
Yeah. Okay. Right.
And insofar as your lordship has a point about the meaning of purported in the context, the point of this letter is to clarify that point, to put it beyond issue, that we were not challenging the entire trading relation. We were not seeking the full judicial inquiry. Then in terms of, so that's clarification. And there is also, of course, the admissions made under RDC 15.1, and your lordship will have read those, so that so Lanka entered into contracts with Renish for both of the award letters. So those were genuine, and I'll come to that in a moment. And also the deliveries of oil were made with the first 3 of the 6 cargoes.
Yeah.
So paragraph 9 in the particulars of claim.
Yes. Yep.
These are the facility agreement representations. So the facility agreement was required for the purpose of genuine bona fide commercial arrangements.
Yeah.
And the Renish intended to make repayment of all sums due. Obviously, the emphasis being there on all sums due under the facility agreement. Now, those representations are admitted by Renish and Mr. Mehta. And the reference, for your lordship's note, that reference is B194, paragraph 5. I'm happy to look at it.
Yeah. As a matter of interest, I know they're admitted. Just for my note, where do the representations come from? Is it from the terms of the facility agreement, or other representations are made in some other way?
Well, we emphasize particularly implied representations.
Yes, implied from the terms of the, implied as a matter of construction from the facility agreement, or implied in some other context?
As a matter of necessary construction, necessary implication, Lord.
Right, just from the nature of the transaction.
Yes.
Yeah, okay.
My Lord, there are a number of DIFC cases involving trade finance fraud where a party essentially runs off with the money and absconds.
Yeah.
And the inference is that, particularly if that happens fairly quickly, that the trader had an intention, never intended to repay the finance, that was always the intention. And the fraud in terms of deceit therefore arises by reference to the implied representation of an intention to make repayment. And I realize that there are some contract lawyers who don't like that. I realize that, that it is sometimes seen as turning a deliberate breach of contract into a deceit. But there are strong cases in the DIFC and other common law courts where it's accepted that this sort of fraud is essentially a species of deceit by reason of the implied representation of an intention to make repayment.
Yeah.
Para 12 then deals with the payment representations. So again, the implied representation as to intention in respect of the payments rather than the facility agreement, and also the representation that the payments were required pursuant to a genuine bona fide commercial arrangement, which we've already discussed.
These are implied representations again, are they?
My Lord, yes.
And they arise with the request for an advance in each case.
My Lord, yes. We'll see there's an email whereby Miss Bansal, who's one of the managers at Renish, forwards a package of documents which include the prime contract and the pro forma invoice, and we'll look at those.
That's the utilization request, is it?
Well, there's usually an covering email a form of utilisation, an application for funds transfer, the prime contract, the pro forma invoice, the acknowledgement of receivable, the assignment of receivable, the acknowledgement of the assignment of receivable. So there's a whole package of these documents, and it is implicit, we say, in these documents that the finance is required for a bona fide transaction and that there is an intention to make full repayment.
Yeah. I think I understand that. I just wanted to make clear that, make sure I understood it correctly, that there are in effect 6 payment representations. There's a package of payment representations made on 6 occasions. That is to say, when the advance is requested.
My lord, yes.
Yep, that's fine.
And I accept that our case in respect of the payment representations is arguably easier than our case in respect of the facility agreement representations, because for those one has to infer further back to February 2017. But we are still able to make that case, because when one looks at the related activity, when one looks at the setting up of the NBK accounts, for example, involving the use of Renish employees, we say that additional circumstance, which is a pleaded primary fact, that when you look at those circumstances, you can in fact infer that not only were these representations as to intention and representations as to the bona fide trading arrangements, not only were those representations made each time in respect of each payment, but they were also made back in February 2017, and indeed throughout February 2017, when the facility agreement was being negotiated. Now, just finishing off on para 12, this is curiously not admitted formally, but is said to be broadly accurate. And for that, we need to go back to page 194. That's paragraph 6.
Yeah, I wasn't quite sure what it meant.
No, well, firstly, the non-admission is curious in itself, because we are pleading an implied representation. Ordinarily, that is something which is susceptible to being admitted or denied. But anyway, it said that there's no admission made. And also, it is said that paragraph 12 is said to be a broadly accurate account of discussions that took place.
But I'm not sure what discussions are referred to.
No, and as I say, in respect to the payments, it is clear that the primary representations are made by the presentation of the package of documents and the emailing of those documents.
Okay.
Okay, and going back to paragraph 12, what then follows is A through E are essentially particulars of the arrangements. So A, there's agreement with Lanka. And one would obviously want to qualify that in saying, well, we entirely accept, and your lordship will have seen the admission, that the Lanka contracts were genuine agreements by Lanka.
Yeah.
But that's still part of the arrangement, which is the wider arrangement, which is said to have been genuine bona fide arrangement. B concluded a sale agreement with Prime. Now there we do say that the sale agreement is a sham arrangement. It's not a bona fide arm's length sale agreement.
Yeah.
C, Renish was to make advance payment to Prime in consideration for oil. So right at the outset, when we were pleading this case, shortly after obtaining the worldwide freezing order, it was up front in our case that the representation was that Renish needed contractually to make advance payment to Prime, and that is clear on the face of, for example, the pro forma invoices, that payment is to be made in advance, and it is implicit, we say, in the request for a payment under trade finance. If the supplier is willing to supply on credit, you don't, on the whole, need trade finance. It's precisely because the supplier wants payment before they ship that you need trade finance to bridge that funding gap. And then D.
So the emphasis on C then is on the word advance.
My lord, yes.
Yeah.
Because we say that's implicit in trade finance, and it's explicit in the documents that make up the package. And yet it is quite clear, and the experts are agreed, that in fact Prime never required payment in advance.
Yeah.
And then D, Renish is to ship oil to Lanka, so that's a matter of Renish's intention. And then E,
And
Lanka would...
Just on E, sorry, on D, do you accept that there's no breach of that one, is there?
Well, insofar as it's not perfectly pleaded, but insofar as we say Renish was then to ship, we would say that that's a pleading of intention, that Renish intended to ship the oil to Lanka.
Yeah, and that's what was done with the first three.
Well, it was done with the first three, but yes, sorry, the oil consignment is the particular oil consignment in question.
Oh, I see. Sorry. Yeah, okay.
Each payment.
Yeah, thank you, yes.
And then E, Lanka would pay pursuant to an assignment of ours receivable. So again, that again is a matter of intention. And insofar as there was no shipment for payments 4, 5, and 6, there was no intention that Lanka would in fact pay, because Lanka would only pay if it received those consignments of oil.
Sorry, just being clear as to this. As regards B and C, you say that all six advances, sorry, the representation in respect of each of the 6 advances was false with regards B and C. But as regards D and E, is representations as regards 4, 5, and 6 that are false.
Well, my lord, the representations were fraudulent in respect of all of 1 to 6, but I would accept that there is no loss suffered in respect of 1, 2, and 3.
Why is it fraudulent as regards D and E? As regards 1, 2, and 3.
Well, we simply don't know whether the oil represented was the oil sent. There is no documentary evidence to suggest that it is actually that oil.
This question, the oil, I see. Oh. All right.
That's clearly less important.
And the oil that got, yeah, okay. But the focus is, for D and E, the focus is on 4, 5, and 6.
So, my lord, we say the representations implied are common in trade finance. That if finance is applied for another purpose or is dissipated, there is no hope of repayment, and invariably one finds in practice that the trader then absconds. And the inference that is drawn is that the trader never intended to apply the trade finance for the agreed purpose, or indeed to repay the trade finance in full.
And that is presumably fact. That's an inference, and that, as you say, and that is fact dependent. And one of the relevant factors would be the time lag, or the gap rather, between the initial setting up of the. I'm talking about the facility representation at the moment. But the
yes, so there's a certain amount of back inference, if you like.
Yeah. If, for example, the facility had been given 3 years beforehand, and there had been 3 years of decent trading, it's quite difficult to relate a fraud, if you like, committed 3 years later, and refer it back to a breach of the falsity of representations at the beginning.
I would accept in those circumstances the inference is lighter,
Yeah.
unless, of course, there's other extrinsic evidence. And in this case, in respect to the facility agreement representations, the setting up of the bank accounts, which were used as the receptacle, and the operation of those bank accounts by Renish employees, we say that that indicates that what happened in terms of the use, the specific use of those bank accounts to transfer large round figure numbers between accounts without scrutiny, that is the extrinsic circumstance which actually significantly strengthens the inference that in fact this was all intended and planned back in February 2017. And one adds to that the fact that these companies appear not to have had any significant trading relationship pre-2017. And that Prime indeed had relatively little trading. Indeed, its 2016 figures imply that its revenues, its turnover, was around $50 million.
Yeah.
And one sets against that the fact that there's a significant emphasis at various points in the evidence of Prime being a very significant trader. There's an attempt in the facility agreement and the negotiation of the facility agreement to set up Prime as being a significant local trader. But the reality is that it was a relatively minor, it had no specific trade or significant trade with Renish prior to 2017. And in those circumstances, the projection of Lanka as the intended purchaser and Prime as an intended supplier, coupled with the setting up and operation of those bank accounts, shows that there was an intention right from the outset, back in February 2017, that the facility would be used fraudulently, as indeed it was. So I take your point about the fact that it's hard to relate back on the basis of what happened is likely to have been intended. But when one looks at the surrounding circumstances, we say that evidence in that case is still compelling.
Yeah, I see. Thank you.
And just finishing off on the legal analysis, we do refer to the Barclays and Afras and Nanda Kumar case. Your Lordship has that in Bundle H. I will take you to a specific paragraph of that in a moment. But essentially, that was a slightly more sophisticated. Your Lordship may have heard of the case. Corinth Pipeworks and Barclays is the leading case on party jurisdiction of the DIFC court. It went to the Court of Appeal on jurisdiction. But essentially what happened was that a fraudulent trader, a Mr. Nanda Kumar, took the finance that was provided by Barclays to pay for one set of pipeworks to one customer, and then used the second round of finance to pay off the supplier of the first set of pipeworks, in circumstances where it then clearly was not going to be able to pay for the second consignment of pipes. So inevitably, Mr. Nanda Kumar then absconded. But in fact, it was the supplier, it was Corinth Pipeworks, that was left out of pocket. Corinth Pipeworks had a claim against Barclays because Barclays' relationship manager looked like he may have been implicated. Barclays had to pay $4 million to the Corinth Pipeworks, and Barclays then came after its former client, Mr. Nanda Kumar, who by this stage had absconded to India, had destroyed all his documents, and was essentially playing a minimal part in the action. And the analysis of Mr. Justice Steele in that case is consistent, we would say, with the way our case has been pleaded in terms of the implied representation. So without saying more, if I could take...
Are you muted?
No, sorry, you were reading, sir. I'm not, Lord. I didn't want to.
I was just trying to find the paragraph. What paragraph is it?
Paragraph 84. It's page
H349. I have it. H378 I've got.
Sorry, yeah, sorry. I lost the paragraph, but it's paragraph 84, which I will just find. So Afras and Mr. Kumar are liable to Corinth under Article 36 of DFC Law 5 of 2005, which provides joint liability arises where two or more persons conspire to do an unlawful act with the intention to cause loss to the claimant, and loss is caused to the claimant by the performance of at least one of them of the unlawful act. They're also liable to Corinth under Article 31 of the DFC Law of Obligations for the deceitful misrepresentations, which were the unlawful acts carried out pursuant to their conspiracy. The first dishonest misrepresentation that they made to Corinth was the payment representation, i.e. that they intended that Afras would pay Corinth for the Bechtel and PDO pipes. So pausing there, that's the implied representation as to intention to repay. This representation was made at the time when PDO and Bechtel contracts were made, and at all times when the goods were being shipped and while payment was outstanding. The falsity of this representation and their dishonest intention behind it are manifest from the dishonest statements which they made to Corinth about Afras not having been paid by Bechtel, when in fact Bechtel had paid in full by the 27th of March 2009. The second dishonest misrepresentation was that Afras was to use the trade finance to pay Corinth under the PDO contract. In fact, as is clear, Afras used this trade finance to pay off the Bechtel debts. In making these payments to Corinth, they also misled the bank as to what they were using the PDO facilities for. Their dishonesty is also manifest from the doctoring of the bank's emails, which were forwarded to Corinth in an attempt to fend off Corinth's demand for payment. Finally, their dishonesty in relation to the doctoring of emails was uncovered. Afras and Mr. Kumar then invented the 19 million commission claim with the assistance of Mr. Moiras in an attempt to provide a substantial set-off against the $24 million owed to Corinth. In an attempt to cover their tracks, they disposed of all of Afras's computers and servers. And again, Mr. Nandakumar disappeared back to India after a long trading career. Essentially, at the end of his trading career, when he was retiring to his villa in India, the temptation of one last round of trade finance and then absconding with it simply proved too much. But the analysis there in terms of implied misrepresentation, in particular as to intention and as to the use of the funds, we say is critical, and it is an analysis which the DIFC court has used properly before in this very important previous case.
Can you help me? I could read the whole case. I will probably, but the representations there were all implied, were they?
They were, my lord, yes.
Thank you.
So there was a fraudulent implied representation that that Afras and Nandakumar intended to pay the manufacturers, and that was the payment representation. And there was a trade finance representation so defined that the trader intended to use trade finance to pay the supplier under a particular contract, because the sophisticated fraud there was creating confusion as to which contracts were being paid.
Yeah.
Sophistication of that in terms of trade finance fraud is that as the fraudster, you extract the finance early, but then because you create confusion as to what is being paid and what hasn't been paid, the moment of truth, of reckoning, is then delayed because finance under contract 2 is used to repay contract 1, and it's only at the due date for repayment, the maturity date under the second trade finance agreement, that the fraud is exposed. And so that gives the fraudster a longer period between extracting funds and having to abscond to avoid contractual claims. We've dealt with Paris 9 and 12. We need to deal with paragraph 40.
Yeah.
Knowledge and intention. I'm aware that it's now 11 o'clock. So
how do you want to proceed? How long do you think you're likely to want to be, knowing the level of interruption I've been indulging in so far?
There's quite a high chance I won't finish. That is almost inevitable. I don't think I will finish today. If we have another 2.5 hours. I mean, I could go faster on the assumption that your lordship would then have to rely on the transcript. But if your lordship is finding it useful to have this discussion as we go, then I would propose that we continue tomorrow.
Right, in which case there's no particular point in running to the wire today then. So why don't we, what time do you want to finish today?
Well, if we break for an hour now, and then do another final 2. So it's 11 UK, 2 p.m. Dubai now. If we go until midday UK, 3 p.m. Dubai, and if we then do another 2.5 hours.
I wouldn't want to do 2.5 hours then. I'd prefer if we could, you happy to shorten the lunch break to 45 minutes and then go on till, say, 2 o'clock latest UK time?
Yes.
Unless that's going to leave you just with 10 minutes worth for the next day. But I expect you'll be longer than that.
Well, should we see where we are at 2 p.m. having taken a 45-minute
Yes.
adjournment?
I have to leave by 2 or immediately, very soon thereafter. So let's take an adjournment now. 45 minutes. We'll resume. Mohammed, are you there?
Yes, my lord.
We'll resume now. We'll adjourn now and resume at 2:45 Dubai time.
Okay, my lord.
Thank you very much.
Thank you, my lord.
I'm going to leave myself connected but muted.
Likewise, my lord.
Yes. Good afternoon.
Good afternoon, my lord.
At least to those for whom it is afternoon.
My lord, we were looking at the
Yeah.
we were looking at the pleading, and we've looked at paras 9 and 12, which are the facility agreement representations and the payment representations.
Yeah.
The misrepresentation is pleaded in paragraph 40. I can probably take it quite quickly in that we've discussed most of the relevant issues in discussing the other 2 paragraphs. But essentially, it's an allegation of deceit against Renish and Mr. Mehta on the basis that the purported sale was a sham transaction. And I think we've discussed what we mean by that, and we'll explore further by reference to documents. And I should say by reference to the admissions that it's the components that are shams are obviously those except for Lanka's agreement to purchase, which we accept is a genuine bona fide contract, at least by Lanka. And then B, Renish and Mr. Mehta had no intention of fully performing the purported sale or indeed the facility agreement. And I don't think I think I've explained that.
Yeah.
And in terms of deceit, the relevant knowledge for the purpose of fraud, and by reference to Article 31, is that, and that's dealt with. This is dealt with at C and D. Renish and Mr. Mehta knew the purported sale was devised to deceive SBM, so that we say is the relevant knowledge. And then D is the co-relative intention. Renish and Mr. Mehta intended to induce SBM to enter the facility agreement and the personal guarantee. So that's the intention to induce reliance.
Yeah.
And paragraph 41, we plead the knowledge and intention as being that of the owners and controllers. And the owner, obviously, is Mr. Mehta. And the CEO, as the Lordship will be aware, is Mr. Ayaz Ahmed.
Yeah.
So obviously, so far as he's CEO, his knowledge is attributed to Renish. We've looked at the letter in which the admissions were made. I think I would like to emphasize.
Which letter are you talking about?
The letter that was I-759, which your Lordship.
Oh, your letter. Yeah.
Yes, our letter. Sorry, the letter by which we make the admissions, and obviously, para 40 needs to be read subject to those admissions.
Yeah.
Specifically that the Lanka contracts were genuine. I should say that no particularly significant weight was placed on the Lanka contracts. They were never an especially integral part. SPM had been diligently seeking information from Lanka in respect of the contracts, and Your Lordship will see that they inquired in July 18 of Lanka. They made a further inquiry on the 11th of March 2020. And for Your Lordship's note, that is at E96504. Sorry, E6504. And then a further inquiry was made by Dentons on the 26th of January 2021. And that's E6502. And it was that last letter that procured Lanka's explanation at E6498, in which Lanka explained that only that the two award letters were genuine, and that only the first 3 cargoes had been delivered. Yeah. And obviously Lanka is a very significant listed business that is owned by the National Indian Oil Corporation, so we have no reason to doubt its evidence. But at no stage was the claimant shy or frightened of what Lanka may say. We were determined to get to the bottom. We continually wrote to Lanka seeking the information, and as soon as we were informed, as we were provided with the explanation of Lanka, an immediate admission was made, and Your Lordship has that at I383 on the 10th of February 2021. So within a matter of days, we circulated to the parties the knowledge that we now had, that the Lanka contracts, at least that component, was genuine.
The question that arose in my mind, and I think is made by various defendants, was: did you have any basis for suggesting that it was not a genuine contract with Lanka?
Well, our basis was simply that we had written on a number of occasions and they had failed to reply.
That's not a proper basis for pleading that something is a false document.
Well, and I think it was what Prime said as well, that because Prime had said that everything was that the entire contracts were forged.
Right.
But the pleading is not the pleading, and I hesitate to go back to 12. But the pleading is that the payments were required to a genuine bona fide sale purchase arrangement, and then the arrangement as it was presented, in terms of that Renish had concluded a sale agreement with Lanka, that Renish had completed the sale agreement, that Renish intended to ship the oil consignment to an alleged buyer in Sri Lanka, namely Lanka. So the emphasis in 12 is always on the representation that the payments were required pursuant to a genuine bona fide sale purchase arrangement.
Right.
This is not a case where we specifically plead that the Lanka contract is forged or is itself a sham. We just say there was a purported transaction which was not a genuine bona fide sale purchase arrangement. And within that wider transaction, there was an element which was a sale agreement with Lanka and an intention that an oil consignment would be delivered to Sri Lanka. This is not a case where we plead in express and explicit terms that this Lanka contract, or that those tender agreements were of themselves forged or fraudulent or shams. We plead the entire arrangement, which we say is a sham, and we plead that as part of that arrangement, there was this Lanka sale agreement.
Mr. Reid, it may not matter for the purpose of the outcome of this case, but in paragraph 12, you identify what you call collectively the purported sale, each of them. That's points what A to E. Each is a component of the purported sale, and that includes A, the agreement that sells Lanka. And then in 40A, you say the purported sale, which means obviously each of them in relation to each shipment, and its component transactions was a sham. They couldn't be clearer that you're saying that the Lanka agreement was also a sham. I agree that your letter subsequently has departed from that, which I'm glad to note. But the question, it doesn't seem to me there's any doubt about what you were saying at that time. And the question,
it may be, my lord, that I am at fault. If I am at fault, I would urge your lordship not to punish my client.
I'm not going to punish anything. It's not my role to punish our clients, but it just seems to me I was concerned at what might be thought to be a slightly cavalier approach to the veracity or authenticity of the Lanka contract.
Yes.
And
I hope you can see it from my client's perspective, which is that they are presented with a package of documents. They are presented with a customer that has absconded and is failing to engage with them, and they attempt to verify documents that are within that package, and the relevant institution, Lanka, just declines to respond at all to a number of requests. That there may have been some suspicion that this was a sham transaction, even on the part of Lanka, and obviously, even having made that allegation, they continued to request information from Lanka. I hope your lordship will extend some understanding to the position that SPM found themselves in the time, and the decision, or their understanding that they had been defrauded in circumstances where they were unable to verify every single component, and when it has been made clear to them in response to their repeated inquiries that the Lanka contracts are genuine, they have immediately, I mean, they did so prior to a CMC. It was, I remember it well. It was, and clearly this was at a time when the set-aside application was being canvassed, and immediedely wrote to the parties to explain that actually Lanka had given this information, obviously highly material, obviously highly prejudicial to the immediate judgment, and we have made a full admission formally under RDC 15.1. So as I say, it may be my failing, but I can well understand that why SPM formed the view that they initially did, and I'm pleased to say that when they were disabused of that in one small respect, they immediately corrected the position.
yes, well, thank you. Yep. Anyway, where do we go from here?
Okay.
We covered 40, I think, and
I think we've covered 40. Yes, I do just want to deal with the sort of the wider pleading point. There is a case in which Mr. Wheel was involved, SOFA, which deals with this distinction between dishonesty and knowledge, and the extent to which, where one is pleading dishonesty, which is often much more nuanced and complicated, then all of the primary facts need to be pleaded out in such a way that the defendant can see how the inference of fraud is said to arise, whereas an inference of knowledge or intention is often simpler, and therefore there isn't the same expectation that the claimant will plead out specific primary facts in making clear where the pleading of knowledge or intention comes from. I will draw your attention to it. The case is Robert Sofa and Swiss Independent Trustees. The neutral citation is 2019 EWHC 2071 Chancery. Your Lordship has it already in the authorities bundle at H1728.
right. Hang on a second.
I don't know if you.
I don't have anything beyond 1727.
My lord, in the jargon, you need to refresh.
Was added this morning, was it?
It was added this morning, my lord, yes.
Bear with me.
And sorry, I think I may have just given you the reference of the decision below.
trying to refresh and it still won't. Oh. Yeah, it's refreshing. Yeah. Yeah,
Does your
I've got
lordship
it.
have it?
Yeah.
Great. If we could go straight to paragraph 23.
Yeah.
More important for the purposes of this appeal are the principles governing the pleading of dishonesty. There was little dispute as to these before either the judge or us. They were summarized, in my judgment, accurately by counsel for the claimant as follows. 1. Fraud and dishonesty must be specifically alleged and sufficiently particularized, and will not be sufficiently particularized if the facts alleged are consistent with innocence. That's the Three Rivers decision, with which your lordship will be familiar. 2. Dishonesty can be inferred from primary facts, provided those primary facts are themselves pleaded. There must be some fact which tilts the balance and justifies an inference of dishonesty, and that this fact must be pleaded. Three Rivers at 186 per Lord Millet. 3, the claimant does not have to plead primary facts which are only consistent with dishonesty. The correct test is whether or not, on the basis of the primary facts pleaded, an inference of dishonesty is more likely than one of innocence or negligence. And that's the Kechman, the JSC Bank of Moscow and Kechman case. 4, particular dishonesty must be read as a whole and in context. That's the Walker and Stones case mentioned in passing this morning in terms of not, if you like, salami slicing of specific elements and requiring specific proof in respect to those specific elements. So reading on at paragraph 24, to these principles, there should be added the following general points about particulars. 1, the purpose of giving particulars is to allow the defendant to know the case he has to meet. Again, Three Rivers, but per Lord Wolfe, Master of the Rolls. 2, when giving particulars, no more than a concise statement of the facts relied on is required, and that's the McPhillamy decision. And 3, unless there's some obvious purpose to be served by fighting over the precise terms of a pleading, contents over their terms are to be discouraged. Again, the McPhillamy decision at 793D. And paragraph 29, picking up at paragraph 29, in breach of trust in respect of each payment made by the defendant to Hyman Sofa out of the Puyol Trust. And then if I could invite your lordship to read 1 to 7.
This is quoting the pleading, is it?
Yes, and you'll see there the particular dishonesty, and they are pleaded at within paragraph 30 at the bottom of that page of the report. I should add that the defendants had no particular difficulties with the pleading and had not raised any request for further information, which they could have done. That, of course, is the same in this case, where there is no RFI, or indeed there is no application to strike out the pleading, which could have been made if there were concerns about a failure.
I don't think I've never understood it to be part of a defendant's obligation to improve the case against him.
Well, if they fail to understand it, they have the ability to make a request for further information.
Yeah, if they fail to understand is one thing. If the case says you rely upon A, B, and C, it's not for them to say, and you also rely upon D, E, and F.
No, but if they say A, B, and C provides no basis for an inference, and we don't understand what you mean by A. And on the basis that it doesn't provide a pleading, we're entitled to strike it out. That in our submission would be the position that a defendant would ordinarily take in this situation.
No, the defendant is under no obligation to apply to strike out. That just gives the claimant an opportunity of improving its case. A sensible defendant often will just let it lie and let it go to trial on the basis that the claimant will be stopped from going beyond his completed case. That's my understanding from my experience, but you may tell me I'm out of date.
No, but I do notice, for example, the comment in McPhillamy that that unless there's an obvious purpose to be served by fighting over the precise terms of a pleading, and I would emphasize, not least at trial, by the time you've got to trial, contests over the terms are to be discouraged. So
yeah, I agree.
The idea that a defendant leaves an uncertainty as to the case being made against it until trial, and then in a glorious aha moment seeks to explain that it's not, that the relevant primary facts are not fully particularized. That seems to me precisely the vice that the court identified in McPhillamy.
All right.
And I do just want to finish on this with paragraphs 30 and 32. So paragraph 30, counsel for the claimant submitted the judge was wrong to hold it was mandatory for a particular claim to identify at the outset the individuals whom the claimant alleged to have had the relevant knowledge at the relevant time, and that it was permissible for a claimant to provide such particulars subsequently in an appropriate case following disclosure. In support of this submission, he relied before this court, although not before the judge, upon Rigby and Decorating Den Systems Limited, an unreported extemporary decision of a two-judge constitution of this court, consisting of Lord Justice Peter Gibson and Justice Hale, dated the 15th of March 1999. In that case, the Lord Justice Peter Gibson said, "It doesn't seem to me a necessary requirement for a pleading of this nature, where it's quite clear that fraud is being alleged, and where the pleading expressly states that the defendants had the relevant knowledge. The particulars of knowledge must be given. That, to my mind, is sufficient to enable the plea to withstand an application to strike out. It was, of course, open to the defendants to seek further particulars of that pleading of knowledge, and if they'd not been provided, it may be that the defendants could have proceeded to seek some sanction. But in the present case, it has not been asserted by the defendant that the defendants were unaware of the plaintiff's case against them. And as I've said, they have at no time sought to have that knowledge particularized in a way which could lead to the striking out of the action." So Lord Justice Peter Gibson is in effect answering the point that your lordship raises, that where a defendant, and certainly the first and second defendant, has not sought to challenge the pleading of the relevant knowledge or intention in this case, and where, if they had had those concerns and if they had not understood the case in full, and that ultimately is the question, is whether the defendant can properly understand the allegation that has been made against it. And in our submission, it is quite clear that the allegation of fraud relates to the absence of an intention to repay the finance in full, and the absence of a bona fide agreement which was relied on in procuring the finance. So in those circumstances, we say the nature of the fraud is clear. I'll come on to the primary facts, because actually, although Prime, by its very eloquent written submission, sought to suggest that there was an absence of primary fact, actually, when one looks at this pleading, it is all there. So we will look at that in a moment. But before we do, could I just finish with paragraph 32 of this judgment, which is the Court of Appeal endorsing Lord Justice Peter Gibson's statement of principle. So paragraph 32, whether or not it's technically binding, I see no reason to differ from Lord Justice Peter Gibson's statement of principle. I do not doubt that where an allegation of dishonesty is made against a body corporate, it's necessary to plead the relevant state of knowledge of that body at the relevant time. I do not accept, however, that a mere failure to identify at the outset the directors, officers, or employees who had the knowledge means that such an allegation is liable to be struck out without further ado. Clearly, such particulars should be given as soon as is feasible, and there may be situations in which the claimant's unwillingness or inability to give such particulars when requested to do so justifies striking out, but that is another matter.
Yes, but you've missed out 31. where he distinguishes Hersey and makes the point that Hersey was a case where serious accusation had been made against identified individuals, but no particulars of the fact relied on as substantiating those allegations had been given. That's rather our territory here, isn't it? I mean, you say in 40A the purported sale in each case was a sham transaction, but you don't anywhere say that there was no real difference between Prime and Renish and any of the matters you've about this morning.
Well,
So how is it? Yeah.
Mr. Wheel takes the strong point that in Hersey, there was an issue about identifying who the relevant individuals were.
Yeah.
Your Lordship. But in this case, it was entirely clear that we're talking about Mr. Ahmed, the CEO, and indeed Mr. Mehta, the owner and managing director. And to your Lordship's earlier point, we say it's implicit where you're saying that a purported commercial arrangement between two parties is a sham, is that those parties are in fact close, that they are not bona fide at arm's length. Now, I accept in terms of the evidence as to why we say that they are close and it was a sham. In terms of, for example, the sham email exchanges, clearly that is evidence that we say shows that they were close and shows that these were not arm's length bona fide commercial arrangements. But the core pleading in our submission is there.
I would have expected under 40A about the sham transaction, I would have expected some pleading to identify that the fact that you were going to try and prove, one, that they presented forged documents effectively, not recording accurately the terms of any sale, and two, the fact that that Renish effectively were running the private office and so on. So there's no reference to any forged documents at all in this pleading.
Well, we don't allege forgery, my lord. Prime alleged forgery.
We
say no, we don't allege forgery. We say that these are sham, as pleaded. We say these are sham transactions.
You say that these are okay. They presented false documents rather than forged documents. You say they presented
documents that were shams. They were parties that were close. They were acting essentially as a single enterprise, and they presented documents which specifically suggest that payment is required in advance, and that we plead.
Where do I find that in your pleading?
Well, if one looks at paragraph 12.
No, that's the representation. Where do we find in your pleading that the fraud is committed by the presentation of false documents and so on? But you can go to 12 if you like as well.
Well, 12 is the representation.
Yeah.
The payments were required for a genuine bona fide sale purchase agreement as follows. And for example, C, Renish was required to make advance payment to Prime.
Yeah.
That was the sham, or part of the sham. And then if one goes to 40, the pleading that those forged sale and component transactions were a sham transaction, that they had no intention of fully performing the terms of the sale. And that C, that they knew that the purported sale was a device to deceive SBM and defraud it. And then one sees the elements thereafter pleaded. And then if one looks at the narrative, Lord, you see, for example, the 18th of June.
No, I'm concerned with the dates earlier than that. I agree you've gone into a lot of detail on the 18th of June onwards, but there's nothing about presentation of false documents
My lord, that's the nature of a sham transaction, is you present documents which do not represent the true arrangement between the parties.
Okay. I hear what you say.
Lord, I'm great. There's a presentation of a purported sale, which is dressed up as a sale requiring payment in advance. That is a sham because it's not the real agreement, because there is no real commercial agreement between the parties, because that is a sham. I take your lordship's point about the evidence, or put another way, the secondary facts in relation to the proximity of and clearly in preparing for trial, one goes through thousands of pages of documents, and it becomes absolutely clear that Renish is doing everything in terms of the administration, in terms of opening the bank accounts, in terms of operating the bank accounts, in terms of dissipating the funds, in terms of stalling the bank, in terms of presenting false certificates to the bank. And from that, there is very compelling evidence of the sham nature of the transaction, of the fact that these are not bona fide arm's length parties. These are parties that are close, and this is a sham commercial arrangement. Now, we say that what follows is the evidence. And for example, we have the stalling in June. We have Mr. Gupta.
I'm not interested in June, July at the moment, although I'm happy to be interested later on. But I would have thought that the matters you've spoken about, the fact they were in the same offices, they presented documents which weren't the real thing, that the payment was such and such, and all those are matters from which you can draw the inference that they were sham transactions, but they ought to be pleaded.
Well, for example, if one looks at paragraph 48, one looks at paragraph 43. I admit that your lordship may have a particular focus at this point in a particular period of time, in terms of the earlier in 2018. But actually, the extent to which they were operating as one enterprise, and this goes to the point about looking at everything in the round and not taking a very sort of laser-like view. If you look at what's happening in June in terms of the stalling, in terms of the sham email exchange, if one looks at Mr. Gupta's role in that, as a Renish employee pretending to be prime, one can infer from that, which is a primary fact as pleaded, what was going on throughout the relevant period in 2017 and 2018. And that, I think, is the point that was sought to be being made in the Walker and Stones case, that the particular dishonesty must be read as a whole and in context. That, it isn't a case of saying, well, as at the time that this particular payment representation was made, can I then, and at that precise point, identify relevant primary facts in relation to the intention at that point. Your lordship doesn't need to be that precise in terms of the analysis. What your lordship can do is look at all of the primary facts
Mr. Reid, I'm not talking about my decision making. I'm talking about fair notice to a defendant. It seems to me, sorry, I was going to say, I would have expected the sham transaction allegation to be an inference drawn from many documents, many facts, which you've told me about in the course of this morning, but none of which find their way into the pleadings until you get to June. There we are.
If your lordship is taking that approach, and if it is relevant to your lordship's decision, which I accept is it may be an assumption, but if it is, I would urge upon your lordship consideration of the distinction between what is a primary fact, what is a secondary fact, by definition of the assumption that something is a primary fact, and then what is the evidence that one hangs on the pleading by reference. And clearly, we're not supposed to be pleading evidence. So clearly, what is pleaded in June are, in our submissions, primary or secondary facts. I have to accept that inevitably in the course of trial preparation, one discovers documents in the thousands of pages of underlying documents which further evidence the sham nature of the transaction. No doubt, in hindsight, in a perfect world, one would replead at that stage to add those, whether it's primary facts, secondary facts, or as evidence. But they are very much in our submission. They are matters of evidence.
Okay, thank you.
So in terms of the knowledge and intention that are at the heart of this case, we do say in terms of pleading the primary facts that clearly the representation is a primary fact, the sales, the fact that the sales agreements are shams is a primary fact. The fact that there's no intention to perform the facility agreement in full, we say that is a primary fact. The delay and the fraudulent excuses set out in paragraphs 42 and following are primary facts. The absence of any honest explanation, as pleaded at paragraph 49, is itself a primary fact. The absconding shortly after the default in repaying the fourth payment, that's at paragraph 50, that's a primary fact. The failure to comply with the worldwide freezing order, dealt with at paragraphs 51 and 52 of the pleading, again a primary fact. The table 58, disbursements with no legitimate commercial purpose, again we say a primary fact. And the bank accounts set up to facilitate the transfer of funds quickly and without scrutiny, that's pleaded at paragraph 61. So that is actually going back into the earlier part of the story. That too is pleaded. So, my lord, even if there were to be facts that you say we ought to plead it but didn't, there are still in our submission ample primary facts pleaded on which to base the allegations of sham transaction, the allegation of a lack of intention, and the allegation of fraudulent misrepresentation. So drawing all these threads together, we say the claimant is required to plead and show facts that are more consistent with fraud. So that there has been a myth that one has to plead facts and show facts that are only consistent with fraud. That myth has been exposed, and we saw that point considered in the SOFA and Swiss independent trustees decision. That's the reference to Lord Millett and the facts that tilt the balance.
There's only balance of probability, and there's the same test for fraud as for any other balance of probability case.
My lord, yes. And as we've seen, Walker and Stone suggest that particularly this is to be read as a whole and in context. I wonder if I could just look at one decision, the decision of Mr. Justice Eder in the Otkriti and Urimov case. And that's at page 8384. But I wonder if I could take your lordship to H419.
Yeah, I have it. Yeah.
Paragraph 89. As submitted by Mr. Berry, the last point is important, or at least potentially important in the case. I'm prepared to accept that in a very broad, general sense, it may well be true to say that it's inherently improbable that a particular defendant will commit a fraud. But it all depends on a wide range of factors. For example, if the court is satisfied that a defendant has acted fraudulently or reprehensibly on one occasion, it cannot necessarily be considered inherently improbable that such a defendant would have done so on another. Or if, for example, the court is satisfied that a defendant has created or deployed sham or false documents, the court cannot assume that it's inherently unlikely that such defendant did so on other occasions. For the avoidance of doubt, I should make absolutely plain this is not to say that inherent improbability is irrelevant. On the contrary, as suggested by Mr. Casella, I accept, of course, that the court should take into account the inherent improbability of an event taking place, as is made abundantly plain in the passage being put. However, as it seems to me, the court must in each case consider carefully what is and what is not inherently probable, having regard to the particular circumstances, but the truth in civil cases always remains the same, the balance of probability. And then just picking up 90, the quotation, the decision of Lord Justice Ricks in one of the many Ablyardov decisions. It is, however, the essence of a successful case of circumstantial evidence that the whole is stronger than the individual parts. It becomes a net from which there's no escape. That is why a jury is often pressed to to avoid piecemeal consideration of a circumstantial case. Picking up the end. Circumstantial evidence works by cumulatively in geometrical progression, eliminating other possibilities.
Yeah, well, that's well known. Yeah.
So that's the warning, if you like, against over detailed analysis of specific elements.
Mm-hmm.
And then my third point in drawing threads together, I think is probably already been made by reference to the McPhillamy case, i.e. that the pleading is required to be a concise statement of facts in order to communicate the general nature of the pleader's case. And indeed, in the Blue Book, in the RDC commentary, there is reference in note 17.17.5 to a decision of the DIFC Court of Appeal in Hague, adopting the comments of Lord Hope in the Three Rivers case. The balance is always between permitting the other side to know the case made against them and giving unnecessary particulars in such a way as to lead to delay and unnecessary interlocutory battles, which I think we've seen that has been adopted and followed by the DIFC Court of Appeal.
Yeah.
That's really what I want to say in terms of the general outline and the pleading of the case. That brings me now to chronology, and obviously there's a temptation to divide, contrary to my own injunction, to divide the case up into phases. The first phase might be referred to as the preparatory phase, and that's to say in 2017. And we know that there was an initial trip in February 2017 by Mr. Ahmed and Mr. Mehta to Mauritius to meet SBM in seeking the facility agreement. The initial application for finance was made in February 2017. As I said, there was no evidence of any prior relationship with SBM. So Renish has a number of its own existing banks, but it is seeking this finance specifically from a bank outside the region, a bank that has primarily served Africa and not the Middle East.
So you gave me a date.
Yes, February 2017 is the initial application for finance.
Yeah.
And I should say, if one looks at Mr. Mehta's witness evidence, which is obviously in bundle D.
Yeah.
Take your logic to page 194.
I've just lost. Hang on a second. I've put them somewhere. Page what?
194. This is Mr. Mehta's evidence in respect of the initial approach to reference to the other credit line, other banks.
What
And then
paragraph?
sorry, paragraph 7, my lord, at the bottom of page D194.
Yeah.
And if I could pick up the fourth line in paragraph 7, this approach was useful because it would enable us to develop our existing connection with, among others, Lanka IOC, a state-owned corporation in Sri Lanka and a subsidiary of the huge Indian Oil Corporation. After various meetings and discussions, we signed a contract with the bank, evidenced by a facility letter dated 31st October 2017, and other loan documentation. So the focus right from the
I thought it was November. Is he referring to the same document, an earlier draft or something?
Well, he's referring to 2017 when agents of the bank approached Renish with offers of trade finance. So the initial contacts were in February 2017.
No, sorry. He talks about signing the facility letter on 31st October. I thought it was in November sometime.
By the end of the paragraph, but I think the early section of the paragraph, he's dealing with the initial.
Yeah.
I should have read. I should have started at the beginning. That's my mistake.
No, sorry, my question is a different one. He seems to refer to signing the facility letter itself being dated 31st October, and I thought it was November. I may be wrong.
There is a term sheet. There is a letter that is October. You're right. The actual facility agreement is the 12th of November 2017. I can probably.
I know where it is. Somewhere.
Yes. But the point is that it was the SBM relationship was specifically linked from the outset to Lanka, and we would say that Lanka is obviously a very substantial oil corporation, and that is consistent with an intention to project security to the bank, because ultimately it's going to be the receivable is going to be a Lanka receivable by reason of the assignment of Renish's receivable to SBM.
Yeah.
One sees consistently throughout the documentation references to Lanka as being a major buyer, references to it's being owned by IOC, the Indian Oil Corporation, and to the apparent security in terms of payment with references to government tenders in Sri Lanka.
Are you able to tell me whether the other advances made under the facility agreement, the ones listed on page whatever 4,000 something, whether they all had Lanka as the ultimate buyer?
No idea. So the other transactions financed by SBM were a whole array of other, and in fact, very often the ultimate buyer was either ADNOC or Shell.
Yes, no, that's the seller. Oh, sorry, yes, you're right. No, I think ADNOC and Shell are suppliers rather than buyers.
Sure, but insofar as there was funds raised or there was finance provided, that finance was paid by Renish to ADNOC or Shell as the suppliers.
Yes, you were emphasising under reference to paragraph 7 of Mr. Mehta's statement the importance of the Lanka agreement, sale to Lanka, as being critical to the opening of the finance agreement with SBM. And I'm just wondering whether Lanka, whether of the various 10 or 12 transactions prior to default, whether Lanka featured in all of them or only in the 3 prime deals.
Lanka was the buyer in, I think,
I think it's just
E5485.
Yeah, Lanka was the buyer in the three prime energy deals.
Yes, exactly.
But doesn't appear to be the buyer in the other deals. And therefore, I'm just wondering what light that throws on the suggestion that it was the Lanka connection which, as it were, tipped the scales and opened the introduction to SBM and persuaded SBM the importance of this or safety of this lending.
Well, in respect of this transaction, where the seller is Prime Energy, which is in reality a tiny purveyor of sanctioned oil from Iran, where there was perhaps an intention to distract from the fact that the seller was an unknown, if you like, there is a corresponding emphasis of the fact that the end purchaser, which is the party that will be paying SBM pursuant to the assignment of the receivable, is a major international state-owned oil company. And as I say, every letter, every sale note. I was looking a moment ago at E141 as an example. Perhaps we look at that.
E141. Yeah.
The third paragraph, this is a letter from Renish to SPM, 7th of March, so a month into the negotiations. If one looks at the third paragraph of that letter, as part of global strategy, while we are participating government tenders in Pakistan, Sri Lanka, and other Asian countries, we find huge opportunities in countries like Ethiopia, Kenya, Mozambique, and Tanzania. So they're playing to the African focus of SPM, but also emphasizing that they are participating in government tenders, specifically Pakistan and Sri Lanka.
Yes, well, maybe I misunderstood what you were taking from Mr. Mehta's statement. I thought you were saying that Mr. Mehta was approaching SPM on the basis particularly that he wanted to develop the contacts with Lanka, and that SPM were attracted to do business with him because of the Lanka connection. And I was just wondering how that fitted in with the fact that only the 3 prime energy contracts out of about 10 advances made by the bank seem to have had anything to do with Lanka.
As it happens, it seems that the other transactions were often with other counterparties such as Shell and ADNOC, both of which are very substantial, clearly very substantial oil trading, petrochemical trading companies. But looking beyond the actual trading, when one looks at the pitch, if you like, that is made to SPM, that pitch is very much in terms of Sri Lankan government-owned and Lanka, specifically Lanka, as a purchaser. So in terms of the presentation, there's a very strong emphasis on Lanka, which would have been very attractive.
Yeah.
Could we just look at E645, my lord? Which So this is an email from SBM, Mr. Malik, who's the Trade Finance Regional Director, to Mr. Ahmed, the CEO of Renish. So thanks, Ayaz. We'll now be pushing this forward. So this is June, so matters have moved on. For your contracts, should we start with Pakistan State Oil and Lanka Indian Oil Corp, Ceylon Petroleum? So that's very much consistent with what we saw in that letter from Renish, emphasizing Pakistan and Sri Lanka. And of course, Lanka is the major, as we understand, the leading oil company within Sri Lanka.
Yeah.
And I should say initially, the intention was to Renish sought a $50 million facility. One gets that from E154.
E154. Yeah, I think I've seen that.
Sorry, that looks like a misreference. Well, I can take you instead to another document, which is E2. Sorry, E621.
Yeah.
Actually, picking up at the top of 620, you see Mr. Ahmed again responding to SBM and And he is providing certain details requested by you in red. And then if one scrolls down to the email at the bottom of that page, one sees it's an email from SPM to which he has added information. And one sees in red at the top of page 621 what he is seeking. And the total is 50 million US dollars.
Yeah.
And one sees generally too that he's dealing with a level of concern on the part of SPM about an increase in borrowings, which is said to be referable to an increase in turnover. So there's clearly some nervousness on the part of SPM. And I should say also, by reference to these documents, that it's quite clear that the application is being driven by Mr. Ahmed, the CEO, who appears to be the main point of contact. And it's him who appears to be pushing for the $50 million. And insofar as he is the sole owner of Petro Hub, and insofar as that entity is essentially his personal entity, he ends up receiving a substantial part of the funds that are taken from SPM. The
Yeah.
The proposal is then worked up into a sales note, which I think is an internal document within the bank. We have that at E682. This appears to have been circulated internally in July 2017.
Yeah.
And one sees writ large in terms of the purposes about halfway down page E682.
Sorry, purposes.
There's a box about halfway down page 682 with sublimits 1, 2, 3, and then a column.
683. Yeah. Facility purpose.
I'm looking at 682.
Oh, I see. Sorry. Okay. Yeah.
And your lordship will see that sublimit 1 is identified to finance contracts awarded by various state organizations, and then Pakistan State Oil, Lanka Indian Oil Corp, Ceylon Petroleum, which is on a back-to-back, front-to-back basis. And the sublimit for that is 30 million. But critically, the total limit, the bottom line of that table, is 30 million. So the bank has put its foot down and insisted that it will the total lending can be no more than 30 million. So that's already by July. And then in terms of what matters in terms of security, when one looks at 683.
Yeah.
Again, I'm looking within the table, facility, uncommitted trade finance line amounting to $30 million. So repeating the facility limit.
Hang on.
And then the third.
Sorry, hang on a sec. So where were you read? Oh, I see. Yeah.
And then 2 or 3 lines down, one sees sublimits, purposes again. So this was the bit that your lordship noticed a moment ago. Purposes, contracts awarded by state organizations, again, limited to 30 million US dollars.
Yeah.
Halfway down the page, there's a break between 2 tables, and you see the words to bid contracts in favor of majors, such as, your lordship have that.
Sorry, do that again.
About halfway down the page, you see some words in manuscript.
Yeah.
If you go down
front to back.
Yes, and then if you go down a bit, you see to bid contracts in favor.
Yeah.
Then you see Lanka, again, specifically identified as one of the bullets.
Yes.
As one of those. And again, below that, one sees to cater for procurement of products as follows.
Yeah.
Again, Lanka over page 684 about the 10th bullet in the right-hand column, Lanka IOC Colombo again. Top of page 684, the top right.
Top of 684. Oh, I see, yeah, okay.
And then critically, just below that, one sees client also do small purchases with the following local buyers.
Yeah, I saw that. And then Prime Energy is the last one.
And Vertex, which is one of the so-called Renish related companies. So monies are passed out through Vertex. So in our submission, there's an intention to familiarize SPM with Prime Energy as a local buyer whom they won't have heard of, and who is put forward as being, or presented as being reassuring, because there will only be small purchases from Prime Energy. And of course, the reality is that the purchases from Prime are not small purchases. The relevant purchases are a very significant amount of money.
Mm-hmm.
That then goes to this is the document that then goes to the board credit committee, which insists on the $30 million limit. And we see that in bundle, E 1834.
Yeah.
So that's the minutes of the board credit committee. And the second bullet point, at all times, the total exposure for the client would remain within the limits of 30 million US dollars.
Yeah.
And then the sales note appears to be approved on that basis. So if we could go to page E 1978.
Yeah.
One sees there, stamp approved in respect of the sales note. That's pursuant to the BCC, the Board Credit Committee decision. And then the next relevant document is a signed offer letter, which is at E 2040.
Mm-hmm. Yeah.
Sorry, where I'm just. This may be the letter that was being referred to in October that we saw in the evidence of Mr. Mehta.
Yeah.
This I think referred to as the signed offer letter. So again,
Right.
one sees the uncommitted trade finance line limited to 30 million at the bottom of that page, and then page 2041.
Yeah.
2041, the limit, $30 million. Sublimits, contracts awarded by state organizations, $30 million. And the total limit, $30 million. And then over page 2042, one sees purpose. So these trade finance documents are always limited in terms of the amount, but also the purpose. This limit may be used to finance working capital in the normal course of business and bid for contracts in favour of majors such as. And interestingly, Lanka seems to get is mentioned twice in this particular bullet list. The Lanka Indian Oil Corp, second bullet,
Yep.
and then the penultimate bullet, Lanka IOC Colombo.
Yeah.
Indeed, suppliers top of 2043, also Lanka IOC, and again the same reference at the top of 2043 to small purchases from local buyers, and the last two of those bullets, Vertex and Prime.
You say Vertex is, remind me.
We don't really know very much about Vertex because no one has troubled to explain what it in fact is. It was alleged by Prime and Mr. Sadder to be what he called a Renish subsidiary. Prime's expert, Mr. Drew, then described it as being within Prime's network, so Renish's network, insofar as Renish had some sort of influence or control over its cash flows. We've seen Mr. Mehta's evidence and his pleaded case, the defendant's pleaded case, is that there is no connection, direct or indirect. So until anyone explains to us what it in fact is, it appears to be a mystery, but it certainly is a recipient of funds that are passed out through the Prime MBK account.
Okay. Yep.
And then just for completeness, really, at page 2047, one has the security arrangements. This is just by way of textual understanding. 2.1.1, the personal guarantee of Mr. Mehta. 2.1.5, an assignment of the insurance policy. 2.1.8, a promissory note in favour of the bank. I don't think we need to look at anything else in terms of this document. And then you will see that it is signed by the bank at page 2055, and it is signed by Mr. Mehta on page 2056 on the 12th of November. So it appears to be part of the package that is signed in executing the facility agreement. He signs it both for himself and also for Renish.
Yeah.
Now, it's important in terms of the chronology to understand that at the very same time that these negotiations with SPM are proceeding during the 2017, the first phase, there are three other steps being taken in parallel.
Yeah.
Firstly, a tender is being submitted to Lanka, and the first Lanka award eventuates in January of 2018. One reasonably supposes that those negotiations started much earlier. I don't think we need to look at the Lanka award. For your lordship's notes, it is identified at page D195, paragraph 9.
And what date is the award? In some of those tables it says 16th January, is it?
That sounds right. Yes, I don't know if your lordship has this table. There's a master table. Which
that's where I got it.
Yeah, so the first award is the 16th of January 2018.
Yeah.
So that's the first thing that is happening in parallel. The second thing in parallel is that Prime is being nominally lined up as a supplier, and what one sees is in Mr. Mehta's evidence at D195.
$195.
Yes, at paragraph 10, my lord.
Yeah.
The next step was to arrange back-to-back contracts with one or more of our suppliers. We had already been in talks with Prime Energy in relation to this opportunity.
Yeah.
Now, obviously, we say that actually they were very close and that this was a sham arrangement. But the evidence of Mr. Mehta is that they were already in talks. And given that what he's been describing in the previous paragraphs are the initial approaches to SBM and the tender to Lanka, one assumes that is at some point in 2017 that the alleged discussions with Prime are said to have occurred.
Yeah.
More importantly for our case, the other thing that was happening at the same time as the negotiation with SBM was the opening of a suite of accounts with NBK, and these are the critical receptacle to which SBM made its payments.
Right.
If I could take your lordship to page D102, Mr. Sada's witness statement.
Yeah.
Reading at paragraph 97 and picking up the second sentence.
Yeah.
Aspect of the relationship, Renish suggested that Prime opened an account at NBK so that Prime and Renish shared the same bank, and Renish recommended NBK as a very reliable bank. This would allow us to avoid money transfer fees and costs from one bank to another. We could also transfer funds swiftly, as when funds were deducted from Prime's account. In seconds, it would be in the account of Renish. We could also transfer round figure sums between the accounts, as the bank had completed KYC on both Prime and Renish. So the suggestion is that if both companies are customers of MBK and are within its KYC net, if you like, it would be easier to transfer funds between the two in round numbers in a form that usually attracts some form of banking or regulatory scrutiny without the bank exercising that sort of scrutiny. And we say that this would made these Prime accounts a perfect receptacle in terms of passing money out of the Prime accounts into Renish accounts.
And quite apart from the account being set up, you say there'd be no reason why any money should be transferred from Prime to Renish anyway.
No, because Renish is the buyer.
Yeah, quite.
So, ordinarily, the trade finance goes to the seller. The fact that the seller is then immediately transferring the finance back to the buyer is a nonsense in terms of any sort of commercial understanding of trade finance.
Yeah.
And it's perhaps important to fix the date in this connection. And we have a very helpful letter in this regard in bundle T.
T.
E, yes. This is the. Do I mean T? I do.
You do?
This is the. Yes, I do. It's P page 273, my lord.
I didn't know there was a bundle T.
I think this letter may even have been on Mr. Hogan's list of his favourite documents.
T176.
E273, my lord. Your Lordship may be aware there was a significant jurisdictional battle by NBK to resist providing any information by reference to UAE banking law. The JJC finally determined that it was subject to the jurisdiction of the DIFC court, and it had to provide disclosure in respect of the NBK accounts. And indeed, it provided disclosure not only of the NBK, but all of the suite of accounts. And it provided this, after jurisdiction was established, it was helpful in providing all of the relevant information. And one sees in this letter, the 7th of March, particularly the following information. A, the prime accounts, and I should say those are all of the prime accounts. So there's a euro account, a dirham account, and a dollar account, were opened on the 16th of February 2017 by Abdulhadi Farhang. And interestingly, that is precisely the period when Mr. Ahmed gets back from Mauritius and starts pursuing the trade finance seriously. At that very moment, the prime accounts are being opened by Mr. Farhang, who is the owner of Prime. And equally interestingly, at B, the current authorized signatories of the prime accounts are Abdulhadi Farhang, who is the owner of Prime, but also Syed Adil Naqvi, a citizen of India. And he, of course, as your lordship will have seen, is in fact a Renish employee. So it is a Renish employee who is involved in opening and operating the Prime accounts. Right at the outset of the relationship, because your lordship will recall that this is described by Mr. Sadr as being at the outset of the relationship. And it's these accounts that were used to facilitate payments between Prime and Renish at the very time that the SBM facility was being negotiated.
Can you give me a reference to Naqvi being a Renish employee?
Can I start by taking you to bundle F?
Right. Well, if you just give me the reference for the moment. Are we going to look at this?
F210.
Right. And do you want to stay with this letter or not, or have you done enough?
No, I think we're done with this letter.
Right. F210.
So this is the F bundle is disclosure that was given to us by MBK. And this is the passport, visa, and ID copy of Mr. Naqvi given in respect of the Prime accounts. And you'll see from this is Iqama, his residence permit. So you'll see his name, he's an accountant, and he's identified as, or his sponsor is identified as being Renish Petrochem Fze.
I see. What is this document?
This is his residence permit, his UAE residence permit, which he has provided to the bank as part of the KYC procedures in respect of the Prime accounts.
Yeah.
Dollar account. And then if we could go back 2 pages, he also provides a copy of the relevant pages of his passport.
Yeah.
Back 2 pages. Sorry.
208.
Yeah, here we go. 208. So again, Mr. Syed Adil Naqvi, and critically, what your lordship sees there is his signature. Well, firstly, you see it on the passport. You also see he gives a specimen of his signature, and he signs as Adil, which is his middle name.
Yeah.
And then if we could go on to page 212. NBK runs an intelligence check on Mr. Naqvi to check him out, and he doesn't appear on any blacklist maintained by the banks. In terms of his operation of the Prime accounts, if we could go to F697.
Sorry, hang on. I couldn't pick up 212 because it was the next document. So 212 doesn't tell us anything about Renish, does it?
No, it doesn't. It's just an intelligence check. It's yeah, it's not a particular. important. I needn't have troubled your lordship with it.
So what document do you want next?
If I could take you to F697, this is Mr. Adil, Mr. Nakvi operating the account.
Yeah.
So this is a day after, just in context, a day after the 5th SPM payment has been made. So a day after that payment, we find $1.5 million being transferred by Mr. Nakvi, a Renish employee, to Renish.
The date is the 23rd of May.
If we go to our master table, the 5th payment was the 22nd of May.
Yeah.
How come
it gets transferred a day earlier than the request?
No, well, it's transferred into the prime account on the 22nd. So SBM pay it in on the 22nd. And on the 23rd, okay, Mr. Nakvi is busy paying it out to Renish, back to Renish. And in terms of the shamming, one sees again Mr. Nakvi signing as Prime Energy, although he's in fact a Renish employee, and signing this document on Prime Energy headed paper.
Yeah.
So, albeit one also sees that the bank has confirmed by phone, and this is the stamp about on the right hand side, has confirmed with Mr. Farhang. So that essentially there's a double lock on this account in that Renish are operating the account and paying monies to themselves out of the account, but Prime have got some control in that they confirm the transaction by phone. And then if one goes back to 695.
So, sorry, bear with me. That would suggest, you would say, I think, that both Prime and Renish themselves, through Farhang and Nakvi, both collaborated in making the payment to Renish. It's not just Renish taking over, it's Prime acting as well through Farhang.
Well, confirming the payment, my lord, yes, but the action taken is an action by a Renish employee purporting to be a Prime employee.
Yeah. Okay.
And then if we go back to 695, we see similar transactions, same day, much larger sums, $5.6 million, again to Renish. Unclear why it was necessary to make two different payments.
It's the following day, is it?
Again, it's the day following the 5th payment, 5th SBM payment.
Yeah.
Although this time it's confirmed by Mr. Sadder, I think. But again, Mr. Nakvi making the transfer.
Yeah.
And then if we could just quickly go on to 720. We're now looking date-wise the 10th of June. That is shortly after the 6th SBM payment, which is the 6th of June.
Hold on, can you? He's got to find the document.
720, my lord.
Yeah. F720. Yeah.
So again, a Prime Energy instruction dated.
Yeah.
Stamped with the Prime stamp, Mr. Nakvi purporting to be Prime Energy, Prime letterheading, confirmed by phone by Mr. Sadder of Prime. So everything about it exudes Prime, but the reality is it is a Renish employee who is creating this instruction, and it is a transfer of monies that have been paid by way of the 6th SBM payment.
Transferring them to whom?
This is again to Renish. So
Again.
halfway, Renish Petrochem.
That is, you say that, is that the day after the SBM payment? 4 days after? Yeah.
No, this SBM payment was the 6th, which was the 6th of June. And
Yeah, so
this onward
after.
payment, so it's 4 days after.
Yeah.
But actually, if one's looking at the 6th SBM payment, there were payments made 1 day afterwards. And if we go to page F194,
F194.
yes,
Yeah.
this is a fund transfer firm, application form. The date, top right-hand corner, the 7th of June 2018. So the day after the 6th SBM payment.
Yeah.
$1 million US in terms of amount, so the ultimate round figure number. The beneficiary is identified, its full name, Astron Global. This is the memorial, Granite Memorial Company in India.
Yeah.
Interestingly, the customer's bank account is the USA. Now, if this were genuinely about oil trading, in circumstances where the relevant oil is sanctioned Iranian oil, the idea that one would pass the finance through the US banking system, it would again be extraordinarily surprising. The jurisdiction which one would want to keep as far as possible from would be the US and the US banking system. And the purpose is said to be repayment of loan. And there has been no attempt by any party to explain what loan this could possibly be by a company that produces granite memorials in India. And one again sees the customer signature, Adil Naqvi, Prime, again, stamp, so this is purportedly being done by Prime, and telephone confirmation by Mr. Abdul Hadi Farhang.
Yeah.
And then if we just turn 3 pages on to 197, a very similar document. This is a few days after the 6th SBM payment.
Again to get Astron. Yeah.
This is Astron again. This time, having taken 1 million out, this time they're a bit more ambitious and they transfer $4 million US to Astron, again through its US account, again for the purported purpose of repayment of loan. Again confirmed by phone, this time by Ali Sadr rather than Mr. Farhang. Again the Prime and again Mr. Naqvi's signature.
Yeah.
So at the heart of these onward payments, to recipients who are unidentified, we find a Renish employee subject to phone confirmation by Prime. Also, early 2017, we find the NBK is setting up, well, there is with NBK an account set up for Petromaster. Now, this is the company that was 100% owned by Mr. Farhang and is therefore a Prime-related company. So one has the Prime accounts are set up in NBK, but also a Prime-related account in the Petromaster account. And we see exactly the same pattern with a Renish employee being used as a signatory. But the Renish employee in this case is a Mr. Shoaib Patel. And if one goes to F309,
so F309. Yeah.
Actually, F308, we see his passport. We know he's a Renish employee, and if we could quickly go to bundle E page 2542.
Mm-hmm.
This is an email from Mr. Ahmed to two individuals, but copied to Mr. Sada and copied. If you see the last of the copied parties, Mr. Shoaib Patel, renishpetrochem.com.
Sorry, have I got the wrong? Oh no, okay, I've got it. Yeah. Yeah.
So this is a payment shortly before the first SBM payment. So the first SBM payment is the 30th of January, and a week before, Mr. Ahmed is requesting a payment of 20 million dirham to Mr. Sada, entirely unexplained. But all we need from that document is Mr. Patel, his Renish email address, and there are many other documents that one could point to where he is copied on emails and is using the Renish email address.
Yeah.
Indeed, if there's a pattern, it is that Indian employees tend to be Renish employees.
Yeah.
And we have seen his passport. His customer information form is back in F.
Hey, can you remind me of the reference to his passport? I failed to write it down.
Yes, his passport is F309, Lord.
Yeah, carry on.
And if we could go back into F and go to page 311.
Yeah.
This is part of the documentation submitted in opening the Petro Master account. And this is if one looks at the top, customer information form, and then the box authorized signatory tick. So this is information being provided in respect of an authorized signatory. And the full name is Shoaib Mohammed Patel, Indian nationality. And then curiously, he, at the bottom of page 312, provides not his Renish email address, but a Petro Master Energy email address.
Yeah.
And then at the top of page F313, he identifies Petro Master as being his employer.
Yeah.
And he identifies his job title about a third of the way down the page as being accounts officer. And then he gives a phone number, his work phone number, which is, I can inform your lordship, that is Mr. Sada's telephone number. And at page 316, he gives a transaction profile. So he's telling the bank what sort of transaction to expect.
Yeah.
You'll see number of transactions 2, total amount $5 million. And those are said to be incoming. And then in terms of outgoing transactions, number of transactions 2, total amount $5 million. So he's seeking to familiarize the bank with the sort of transactions that they should expect to see. Then
Yeah.
there's a customer declaration at the top where he says that the information, this is page 318.
Yeah.
So you see the signature by Patel. The date is the 17th of May 2017, so a little later than the opening of the prime accounts. So they're having a sort of a further thought in terms of the receptacle entities and accounts that they will need. Signed by Mr. Patel. And as we say, this is essentially another receptacle. And if your lordship remembers table 58, Petromaster is another of the immediate recipients, but is also a secondary recipient. So that again, so we have the two accounts. We have the prime accounts, which are essentially being opened and operated by Mr. Nakvi. We have the Petromaster accounts, which look on their face to be a prime related entity, but they again are being operated by a Renish employee. And we say again, having another receptacle within the MBK account network so that transactions can be completed both quickly and with minimal scrutiny is an important part of the dissipation of the funds, the proceeds of the fraud on SBM. So by the end of 2017, we have in place the receptacle MBK accounts. We have a purchaser, Lanka, lined up. We have a purported supplier, Prime, and we have the SBM facility.
Right.
That brings us to the facility agreement itself. I know your lordships looked at it on previous occasions, but there are some provisions that I think are worth drawing attention to again. That's in bundle E at page 2304.
Mm-hmm. Yep.
We could go straight to page 2311. About halfway down that page, we have a defined term, import facility limit. So this is the facility limit for import loans, and that is clearly stated to be $30 million. So that limit made it from the offer letter into the facility agreement.
Mm-hmm.
Then, sorry. Yes, tracing through, one sees facility limits and purpose limits within the defined terms. I think we can pick those up in Schedule 4 more conveniently because there's quite a complex inter-reference, if you like, of defined terms. Clause, at page 2327, we have clause 9. Oh, sorry, I should just say clause, sorry, I'm very sorry. The purpose is clause 2.5 at page 2319.
Yeah.
So the borrower shall apply all amounts borrowed to it towards the following purposes subject to compliance with the purpose limit at all times. So you have to comply with the purpose limit, which is in Schedule 4. So A, guarantee facility to issue bank guarantees. B, relevantly for our purposes, import loan, ID facility, LC facility to finance working capital in the normal course of business and bid for contracts in favor of corporations listed in Schedule 4. So again, that reference to the restrictions in Schedule 4. And then clause 2.6, the borrower shall ensure that the facility shall be utilized for the purposes for which it's sanctioned and it should not be utilized for and then various other purposes, including any speculative. The facility is then in page 2320, clause 4, the import loan facility. So that again is the relevant facility for our purposes. And reference there.
So you gave me a reference, Angus.
Sorry, page 2320, clause 4 is sets out the relevant details in respect of the import loan facility.
Yeah.
And one sees that clause 4.1 reference to the utilization request, which is part of the package of documents we will look at. And you see at the top of page 2321 reference to the purposes limit. Also at 4.3 little b, reference to the facility limit. So those two limits are clearly established in the import loan facility provision. And then if we could go to page 2327. One has there the provisions for repayment, the requirement to repay by the repayment date. Clause 10 at page 2328 deals with interest. Worth looking just to pick up the point at 10.1a, that there is a different discounted rate of interest of 2.25% above LIBOR in respect of financing of contracts awarded by state organizations. So again, in terms of the security sought by SBM in terms of financing contracts, where the receivable would be a receivable of a state organization. That is,
so which part of 10 was that?
10, 1, little a. So financing of contracts awarded by state organizations, that finance, the interest is 2.25% against LIBOR. Whereas under B, financing third port shipments is a higher rate, 2.5% above LIBOR.
Yeah.
And then at the bottom of that page, bottom of page 2329, we have the fees, payment, and default interest. So there's a basic interest rate, but there's also a higher default rate if the borrower falls into default. And then if I could go to clause 1520, if we start at page 2338, the clause 15 dealing with representations, the borrower makes the representation.
Wait a sec. Sorry, it took a while for it to bring it on the screen. Yep. Where are we?
Clause 15, representation. The borrower makes the representations and warranties set out in this clause 14. Just stopping there. Clearly, this clause was originally clause 14, and that we'll see how that may be relevant. But in any way, a number of representations of warranties are made. The important ones for our purposes are at 1520, page 234. Halfway down.
Yeah, sanctions.
Neither the borrower nor any of its subsidiaries nor any of their respective agents acting or benefiting in any capacity in connection with this agreement fall under the sanctions list, and the borrower shall not and shall ensure its subsidiaries shall not use the proceeds from this facility in any transaction with or for the purpose of financing the activities of any person subject to any sanctions of the government of the United States of America administered by OFAC. So this warranty and representation was plainly, there was a deliberate breach because Renish was well aware that the oil that would be supplied by Prime would would be of Iranian origin.
Mm-hmm.
And then going on to page 2344, clause 16.4, there are general undertakings given. The borrower further undertakes that it shall. Then if one goes on 3 pages to 2347, then little u, OFAC compliance. Your Lordship will be aware that OFAC is the US body that monitors and enforces the US sanctions, in particular those against Iran and the provision of Iranian oil. And then little u, little Roman 1, the borrower shall comply with all sanctions and acknowledges that sanctions may apply to the facility and or transactions thereunder pursuant to this agreement. And then little Roman 2,
Yeah.
borrower represents the transactions to be entered into pursuant to this agreement shall not violate any sanctions, and that no persons, entities, or otherwise currently subject to any sanctions will not be involved in any transactions hereunder. So again, the Renish would have been was entirely aware that Prime, the business of Prime, was essentially providing cheap oil that had been produced. And then page 2349, we have events of default and little 17.1, little a, non-payment. So any non-payment is an event of default. And then if one goes on to page 2351, little s, where there is an event of default, there is a right of acceleration.
Yeah.
As indeed in this case. And so little s, little Roman 2, declare all outstanding amounts to be immediately due and payable, whereupon each such outstanding amount shall become so payable together with accrued interest thereon and any other sums owed to the bank under this agreement. 2369, Schedule 4.
Hang on. Yeah.
This is Schedule 4, which sets out the both the limit, also the purpose.
Yeah.
The first table, contracts awarded by state organizations, $30 million. So again, that was the limit, and that intended purpose. 2/3 of the way down, import loan limit, again, $30 million. And if that wasn't clear enough, about a quarter of the way up the page, one sees in bold text, the sublimits shall be capped as detailed in the above 2 tables, such that the aggregate outstanding amounts remain within $30 million at all time. Part 2, uncommitted trade limit to be used to finance working capital in the normal course of business and bid for contracts in favor of majors. So again, emphasis on majors, and again, Lanka appears twice on the list. Only 8 major oil trading companies. And in terms of suppliers, in the box in the table in page 2370, one sees in the right-hand column, client also do small purchases with following local buyers, and again, the Vertex and Prime.
Yeah.
My Lord, now I'd like at this point to turn to the closeness of the Renish Prime relationship. I suggested that Prime has almost no footprint in the UAE. You will remember the reference in Mr. Sadr's evidence to him being a consultant with only a laptop and a mobile phone. I don't need to take your lordship, that's at page D12, paragraph 31.
Give me a second, I just want to make a note, a new heading. Right, can you just start that again?
Yes, sorry. Prime has no footprint in the UAE. All it has in the UAE is Mr. Sadr, who is not an employee but a consultant, and he works with a laptop and his mobile phone. And the reference is to, perhaps we should look at it, page D12.
Yeah. This is
this is the affidavit of Mr. Sadr.
yeah.
So paragraph 31, page D12, from 2012 onwards, Prime retained me as a consultant who operated from his laptop and mobile phone. And then B, Prime did not employ any members of staff. Rather, it engaged various third parties and or agents from time to time when necessary.
Yeah.
And that's actually, because what it in fact did was used Renish staff. And it's also said that Mr. Farhang delegated day-to-day control to Mr. Sadr, and that's D81. D81, paragraph 2 of the second statement of Mr. Farhang. So Mr. Farhang is saying day-to-day control was Mr. Sadr. Mr. Sadr was essentially a one man and his laptop and mobile. And what Prime in fact did was to use Renish's offices, its employees, its accounting function, its finance team, its logistics, because Renish had a significant staff and office. If one looks at page E75,
Yeah.
this is the Dun and Bradstreet report, business report that was presented, business rating report that was presented to SBN. And one sees here employees current, so total employees in 2015, 43 employees. And one can see the suggestion that that number is increasing, because in 2012 there were only 10, so they've clearly grown substantially. And one sees too a significant, this is Renish of course, a significant physical footprint. Firstly, the physical address, this is the office space. So they have 3 suites, suite 3704, 3705, and 3706. So this is a third of a substantial tower block in the Dubai Marina area, the Jumeirah Lake Towers, JLT, to people who know the area. So a very substantial office with 43 employees. Sadr, of course, as we know, is not an English speaker. Mr. Sadr, sorry, is not an English speaker. And it becomes clear that he's reliant on the Renish's Indian professionals and managers, insofar as he is operating what purports to be Prime.
Yeah.
And there's some very revealing third-party evidence of the way that these companies or entities related to each other. And that's an email of Mr. Gupta, who was a Renish employee. But again, one who frequently presents as being a prime employee. And that's at page 6462, E6462. Again, this is a critical document in our submission.
Yeah.
462.
Mm-hmm. Yeah.
Mr. Gupta has been emailed by Mr. Sadr, and we see here about the fifth paragraph, he volunteers some analysis. Really shocking how they can involve you in their internal matter, SBM Renish. You were just a supplier of Renish like many other suppliers. No doubt. No. And reference there to some profit sharing, but I would take your lordship in particular to the second paragraph. And to make the above channel more streamlined, Renish main department, like MD's department, managing director's department, finance, shipping and ops, are directly linked with you to communicate. So Mr. Sadr is directly linked to the main departments within Renish. Although it was physically not there, but a deemed office of yours seems inside the Renish. So it's as if Prime's office is sitting within the Renish office. Even you have allotted a few email IDs, open access basis for communication and ease of flow of documents to carry out your business operation needs as mentioned above. There again, the suggestion that there are open access emails to which both parties or both entities will have access for ease of flow of documents and for ease of communication. And one sees looking down that page to reference to RP shipping, which in our submission is one of those open access emails. And he's asked about its use. And Mr. Gupta explains, in routine, I was using it, but ID and password were shared in a WhatsApp group, so many persons may have access to it. So that is an open access email. It appears to be a prime email address. And we will see when we look through some instances of the use of that email, we'll see that it's presented as being a prime email address, but it is in fact being manned and operated by Renish employees. And indeed, if we scroll down to page 6464, we see the initial email to Mr. Gupta from Mr. Sadr. Where Mr. Sadr says, further to our telephone discussion on Tuesday, as part of our disclosure responsibilities in a court case related to Renish, SBM and Prime, we had gone through two mailboxes of RP shipping and RP operations. So Mr. Sadr has been going through the mailboxes of these two prime addresses, which were open access. So they were used by Renish employees, but they were set up on Prime's domain and therefore were obviously accessible to Prime. And indeed, your lordship may remember the reference in the skeleton argument of Prime. And this is a paragraph 16, subparagraph 4, subparagraph B, 16.4b, to the fact that the email was not routinely accessed by Mr. Sadr and Mr. Farhan. And by implication, we say it was clearly being accessed by those two prime individuals. And we say that the purpose of the RP shipping email was to allow Renish employees to present as being prime. Because clearly there are circumstances where it's expected that the shipper will be providing information. And therefore, one would expect that communication to come from Prime, if Prime was a substantial entity. The reality is Prime has no employees. So it uses Renish employees to present as if Prime employees.
Mhm.
Useful Gupta because actually he is he's an integral part of a pattern of conduct whereby Prime documents are produced by Renish employees. And one of the best illustrations of that is the sham exchange of emails in seeking to stall SBM in mid-June 2018, which, as you've seen, we have pleaded. And if one goes to page 5E5371, Your Lordship has here an email from the Prime open access email address, so RP Shipping, Prime Energy, and yeah, so that's a Prime address. If one looks at the footer of the email, we see Mr. Gupta, who is a Renish employee, but is purporting here to have a Prime, to be a Prime employee, indeed to be the shipping and chartering manager of Prime. And specifically, it's worth noting that his telephone number is given as a number ending 4193. And I'd ask your Lordship just to remember that number, 4193, because we'll see it again.
Where do I find that?
Sorry, at the footer, you see Energy, telephone 9714-436-4193.
Yeah.
He is emailing to Renish email addresses, Shipping ME and Finance ME, both Renish Petrochem, in purporting to explain a delay. So with regards to supply of fuel, this is the fourth shipment. Please note the cargo we received from our end supplier is not meeting our agreed specifications with you. We refer to the last test report provided to you. Since we have to now work on a fresh cargo, we request you to provide us with 1 week time to replenish cargo meeting your required specifications. We are fully aware of your supply commitments. However, the situation was beyond our control as the off specification was known only once the cargo was discharged in our tanks. And essentially providing an excuse in seeking a delay as if there was a genuine contractual arrangement or commercial arrangement between Prime as supplier seeking to excuse a delay and Renish as a purchaser. But the reality is, it is Mr. Gupta, who is a Renish employee, emailing Renish email addresses. This is a sham exchange.
Can you just help me? Because I'm only seeing one page out of many. At the top of page 5371, there is a Renish stamp or insignia.
Ignore that for the time being, and everything below that is what I'm looking at.
Yeah, I know you. I just want to know what it is there and why it's there.
I'm going to go up the chain. So the next email up the chain is 5370, page 5370, which is Sandeep of Renish responding to what looks like Prime, but is in fact Renish, saying, ref to subject, please be noted that we are in tremendous pressure from our client. They are chasing us badly. They almost dried up and following hourly basis. So this is presumably talking of Lanka in terms of the sham presentation. Being it is tendered cargo and delivered planned back-to-back basis, we may have to face commercial implications, and that will be passed on to you as it's due to this. So threatening, if you like, legal implications and indeed the possibility of delay damages by reason of the failure to provide. But in circumstance where this is a communication between Renish employees purporting to be Renish complaining about a delay by Prime. And if you're wondering what the purpose of this exchange is, we see that from the next email up the chain, which is Miss Vidisha Bansal, a Renish employee. And she sends the below emails to Mr. Malik of SBM, copied to various other SBM offices, Refer below email from operations. Please note our team is continuously chasing the supplier and is expected to sort out the matter as early as possible. We will maintain our request for 1 month's extension, and hopefully things will be sorted out soon. Please note this is a practical situation which is beyond our control. We ensure there will be no further delays in the next 2 deals. We seek your kind support in this regard as always. So this is the critical moment where the 6th payment has been made on the 6th of June. This is the 4th cargo. Renish knows full well that the cargo is not going to be delivered to Lanka, and that therefore Lanka is not going to pay SBM, and therefore Renish is seeking time from SBM precisely because this is, if you like, the crunch period. This is the period where ultimately in July, Mr. Mehta is going to abscond. And then you see the response of SBM at page 5369. So one has a response at 5369, Dear Vidisha, the below is well noted. However, as mentioned in my previous email, we cannot extend the payment date past the 22nd of June 2018, so essentially refusing an extension. And then a response to that by Ms. Bansal of Renish, again seeking to explain and again seeking a month's time. Significantly for our purposes, this email is copied to Mr. Ayaz Ahmed. He's the CEO. So again, in terms of the number of people who are clearly aware of this shamming exchange, because Mr. Ahmed would have been fully aware that there was no such delay, and he too would have been aware that this was essentially a conversation between Renish employees purporting to be a legal contractual dispute, if you like, between Renish and Prime. And one can go up the chain again, seeking, and one sees further discussion about that is being sought. I do just want to quickly make good the fact that Mr. Gupta is presented as a Renish logistics manager. If I could take your lordship briefly to page E212. You will see this is the key personnel table, my lord. So you'll see, for example, Mr. Ahmed, who's the CEO, while various other key employees, all of whom are managers, all of whom are graduates or professionals. But number 7 is Mr. Gupta. He's described as the Master of Engineering, but he is described as the logistic manager of Renish. That's how he's being presented in this slide deck to SBM. So what he's doing in the sham exchange we've just seen is purporting to hold this, effectively the same role, shipping manager, but in Prime rather than Renish. And indeed, there's a number of emails to which we could take you in which he is held out or holds himself out as being the logistics manager of Renish. And we've seen in that last email exchange, Vidisha Bansal, Ahmed, Mr. Ahmed and Mr. Mehta are all copied in. Perhaps I should have picked up on the fact that Mr. Mehta was copied into that last exchange. Sorry, reference E5367.
Yeah.
Yes, sorry. So if one looks at 5367, both emails, but I think the initial copying in of Mr. Mehta occurs on that email at the bottom of page 5367. So that email we have is sent to Ms. Bansal. He's not even copied. It is sent directly to Mr. Mehta, and it's copied to Mr. Ahmed. And obviously the entire chain was copied and sent to them. So all of them would have been aware of that sham exchange. And then just to complete the narrative, if one goes to 5363, my lord.
Mm-hmm. Yeah.
We see the body of the email explaining the delay, and that is sent by Vidisha Bansal, who is essentially the accounts manager at Renish, curiously using an old name, Richmond Petrochem, which was a pre-2013 name of Renish. But she, as a Renish employee, is sending to other Renish employees using the RP shipping email, the text of an email that she has no doubt drafted. And it is then sent on from that RP shipping, that open access email address, to the other Renish addresses. So we have a Renish employee, Ms. Bansal.
Yeah, as Vidisha.
Drafting an email, Vidisha, drafting an email which he sends to other Renish employee, Mr. Gupta, who is operating the RP shipping email, which looks like a prime shipping email. That email is then sent on to other Renish employees.
So, can you I'm not sure whether I got the right email. 5363.
Yes, my lord.
You mentioned Mr. Gupta.
Yes, because Mr. Gupta is sitting behind the RP shipping email.
That I understand. So I thought you were saying it was mentioned in this email.
Oh.
No, sorry.
So
we're across purpose.
Sorry, I apologize. This is Vidisha drafting the email. And if one then goes down to, for example, 5365.
Yeah, hang on.
You see the draft email, the email drafted by Vidisha, sent from the RP shipping open access email address, sent by Mr. Gupta from that RP shipping email address. Mr. Gupta holding himself out as being the prime energy shipping chartering manager.
So your point is that she has drafted the email, which Gupta then on behalf of Prime sends to Renish.
Renish, exactly.
Yeah.
So the Vidisha drafting it, Mr. Gupta purporting to send it as Prime, and the recipients are all Renish employees.
Yes, I see. Yep.
The next section will be about 10 minutes, my lord. I don't know what your lordship's.
How long do we have to go after this? Sorry, I'm not sounding bored. Stating
well, I think it may take us much of tomorrow, but if we could just do another 10 minutes, I would be. But if your lordship is committed, then I entirely understand.
I'm committed also. We've had an hour and 10 minutes, 2 hours and 10 minutes already this afternoon, I think. Which is long enough. So should we resume tomorrow morning at
yes.
At 11:30 Dubai time, which is 8:30 UK time. Do you think you'll be most of the day or most of the morning or what?
I'd like to reserve much of the day if I can. I don't think we'll go all day by any stretch, but I don't want to commit to finishing by lunchtime if that's not too precious on my part.
It doesn't matter. It's just a question of just give me an indication. Very well. Mohammed, are you there?
My lord, sorry, I didn't hear.
Yes, my lord.
Mohammed, if he's there. Mohammed, we're going to adjourn now, and we'll resume at 11:30 Dubai time tomorrow, which is 8:30 UK time. Thank you very much.
Yes, my lord.
Right, until tomorrow then.
Thank you.
Thank you very much.